Welcome. This is Gary Wickert, and the webinar that we're about to present is Advanced Workers' Compensation Subrogation, Advanced Concepts in Workers' Compensation Subrogation, and this is a complement to the webinar that we presented earlier this spring, which was Beginning or Introduction to Workers' Compensation Subrogation. So there are some subjects and topics that we're going to assume that you are already familiar with because workers' compensation subrogation is complicated and sophisticated enough that we're going to have to spend the full 2 hours this morning going over some of the more detailed and complicated or nuanced aspects of workers' compensation subrogation. Before we get going, however, I want to point out a few thws. With our GoToWebinar attendee interface, there's a few instructions that we have. A few housekeeping items that we want to go over. We're looking at an example on the screen right now of the GoToWebinar attendee interface, which is made up of two parts. The viewer window is where attendees see the presenter's screen. The window can be resized by clicking and dragging the lower right corner. Control panel is where attendees can interact with organizers. You can mouse over the grab tab up here. You see something that looks like this on your own computer, and clicking on the arrows of the grab tab opens and closes the control panel. The audio pane provides audio information. If you have two options. You can join the audio through your computer using the mic and select speakers, or you can just join through your computer. The audio setup, you can click on to select your computer speaker or headset devices, and then you can choose to join the audio through your telephone. You can select use telephone, dial the number listed, and enter both the access code and the audio PIN when prompted. But of course, if you're listening to me and you're in, obviously you've already done that. During or at the end of the presentation, you have the ability to send questions to our webinar staff through the questions pane. You simply type in your question and click send. At the end of the presentation, we will do a Q&A session to answer as many questions as we have time for. During the presentation, we may ask you to answer a question by raising your hand. This is an option located in the grab tab. However, this morning we have approximately 492 attendees from across the country. This includes 18 of those 492 are conference rooms, which contain untold number of people, so we don't know the exact number of attendees. But I did ask Jamie Green to check and see how many people we have repeating from the Introduction to Workers' Compensation seminar, and the number is 216, and I asked that just so I know whether to repeat any old jokes or not. During the presentation, we may ask you to raise your hand. This is located on the grab tab, and if you prefer to keep your control panel open during the presentation, click View in the top menu and uncheck the auto hide. Uncheck auto hide on the control panel. So now that we got some of the housekeeping out of the way, I do have a quick announcement. Our next webinar will be on September 16th. 2010 from 10 o'clock to 11 o'clock Central Time. The nature of the webinar will be construction defects. Chris Miller and Doug Lehrer in our offices will be presenting the webinar, and this webinar will cover the nuts and bolts of construction defect subrogation applicable regardless of whether you're insured as a homeowner with water damage in their basement or a builder whose subcontractors shoddy or substandard work resulted in property damage to a number of homes within a residential development. So it will be a very interesting and in-depth look at construction defect litigation. Also, for those of you seeking CE and CLE credits, we do provide those with certain limitations and with certain help on your part. Today's webinar is approved for 2 hours of Texas CE credit. If you're interested in receiving those credits, please send your full name and Texas license number to Jamie Breen at jbreen, that's J-B-R-E-E-N, at mwl-law.com as soon as is possible after this webinar because there is a time window. We are only approved to offer Texas CE credits at this time with this webinar. If you need CE credits for another state, we can provide you with the appropriate documentation so that you can submit it to your state for approval of CE credits. Due to reciprocity agreements with most states, your request will most likely be approved. For those of you who are seeking CLE credits, attorneys among us, we can provide you with the same documentation that you could submit to your state bar for approval, seeing as Texas is one of those more universal states for CE and CLE credits. Again, send your requests to Jamie Breen at jbreen, J-B-R-E-E-N, at mwl-law.com. So, great turnout today, and it seems that each webinar comes with more and more attendance, which is very exciting. And we're going to talk today about workers' compensation subrogation, and this is going to be a more advanced version. So, looking again, we're going to talk just briefly about the history of workers' compensation subrogation. We covered this in the introduction, and the only reason I bring it up again is because many of the issues that we're going to be going through today deal with situations in which judges, commissioners, administrative law judges have discretion in whether or not to uphold a workers' compensation lien, whether to grant your right of reimbursement, whether to sock the other side or sock you for attorney's fees, whether to reduce your lien based on equitable arguments such as made whole and common fund doctrines. And these are things that we generally associate with equitable subrogation, but workers' compensation subrogation is statutory. It's set forth in the statutes of all 50 states and is very strictly adhered to. But the reason we're seeing a lot of problems and a lot of attacks on your workers' compensation subrogation rights is because of the history of subrogation and because it's not very well understood. Workers' compensation began at the turn of the century, and this is going to be a rough overview because we covered this in the introduction. But workers who were being injured on the job were not covered by workers' compensation subrogation at the turn of the last century, and as a result were able to sue their employer for injuries that were caused by the negligence of the employer. Well, this didn't set well with the labor industry, and this being the Industrial Revolution at that time, the industrial complex and the business lobbies lobbied Congress and lobbied the states of the legislatures of the various states and asked that some mechanism be brought into play. And the first state with a workers' compensation scheme was that of Wisconsin back in 1911. And Wisconsin, you'll understand the nature of it, was going through a progressive movement at the time, fighting Bob La Follette was our governor. Victor Berger, a known socialist, was involved in politics in Milwaukee, and we had a very progressive atmosphere. And workers' compensation is, as we will describe a little later on, a socialist concept. But the purpose of workers' compensation in general, and workers' compensation subrogation in general, is to reduce the burden of insurance on the public, to prevent a double recovery so that the plaintiff doesn't recover once from the employer and a second time from the third-party tortfeasor. And lastly, the purpose is to put the ultimate burden of the loss on the person who caused the loss, the guy who wasn't paying attention and rear-ended your employee, the manufacturer of a product which exploded or caught fire or took off fingers or hands or killed someone because of a defective design or a bad manufacturing defect. And workers' compensation subrogation was purely a creation of statute. In fact, in some states, as we'll talk about, it isn't even a right of subrogation. In the state of Wisconsin, workers' compensation subrogation is an oxymoron. It doesn't exist. We have workers' compensation, and we have a workers' compensation statutory right of reimbursement. There is no subrogation, which is the traditional stepping into the shoes of someone and subsuming their rights of recovery or the right to recover against somebody who owes that party a debt. Most commonly, subrogation, of course, is in the insurance context. So the workers' compensation carrier would step into the shoes of the injured worker and take over his rights to recover against the negligent tortfeasor. But in many states, and including the state of Wisconsin, it's not a right of subrogation. It's a statutory right of reimbursement. And we forget that, and the judges forget that, and the legislators forget that. And that's why we get some of the crazy laws we get, and we see things happening like in Illinois, where you have this bizarre right of contribution, which really turns workers' compensation on its head, or Minnesota, or Georgia, where unless benefits were paid under Georgia law, you have no right of subrogation. And the Made Whole Doctrine is codified right into the statute, which defeats the historical compromise, which I'm going to talk about in a moment. So it's entirely dependent on state law, which means that you have 50 states, and you have the possibility that injuries will happen in one state, benefits will be paid under another, and the employer might be organized and operating under the laws of a third state. So we're going to talk about extraterritorial subrogation, which really is a key. It's really a wonderful tool for maximizing subrogation recovery for us subrogation professionals. Now, workers' compensation in general, as I mentioned, I know it's a socialist concept, and I do that to make a point. Truly, socialism is the common ownership and cooperative management of the means of production. So when I say socialism, I mean there's some that are arguing that, yes, we're heading toward that in our country today, but at the turn of the last century, in 1911, it really wasn't socialism so much as progressivism which drove workers' compensation and created the very first workers' compensation system in Wisconsin. It's a system whereby an employer, without any responsibility, any fault of its own, is automatically, simply by virtue of the fact that it's in America, conducting a business in America, is automatically responsible for millions, potentially millions of dollars in medical expenses, lost wage reimbursement payments, death benefits, what have you, with no limit, even though it's not at fault. And the reason we did that is because society at the turn of the last century decided this was a wonderful compromise, that a social pact was going to be made between the employer, who would now be on the hook for all of this, and the employee, who would now get the benefit of knowing it or he or she will be taken care of in the event of a work-related injury. But he or she is going to have to give up, in exchange for that right, for those guaranteed benefits, its right, or his or her right to pursue or sue the employer for negligence in causing the work-related injuries. So it was rather a novel concept, and one that stems from progressivism, perhaps more than socialism, but nonetheless, it was a situation where we're now dealing with a square peg in a round hole. We have this progressivist concept of workers' compensation in which we've made a deal with the employer. Look, employer, you're going to owe all this money, but you're not going to be sued every time your employee gets hurt. Well, we're forgetting about that, and we're trying to cram the square peg of equitable doctrines into the round hole of workers' compensation, and it's not working in many states. And the lack of understanding of our history and the lack of education among judges and legislators is why we're having this problem. So this is why I spend a little bit of time, even in the advanced section, the advanced session here on workers' compensation subrogation, and going over this. Because again, workers' compensation involves no-fault concepts. It involves a reciprocity, a social pact. You, employer, are going to have automatic responsibility for these scheduled benefits and unlimited medical benefits, which of course you can slough off on your workers' compensation carrier, who then steps into your shoes for matters of recovery and reimbursement, versus the employer's right to be reimbursed. This is just part of the pact that we made, but it's being eaten away because more generic concepts of subrogation are finding their way, weaving their way into the fabric of workers' compensation, which again is the square peg. So the trend in many states, even though equitable considerations don't apply, the Made Whole Doctrine, as we find in Georgia, should never be codified in the Georgia Act. Because the employer, who is, through perhaps no fault of its own, made responsible for all of these benefits is denied the right to recover these benefits back if a third party is at fault, merely because the plaintiff is not quote-unquote made whole, whatever that means, and we'll talk more about that in a minute. So the trend is toward equity, which is completely wrong. We're forgetting the concept, we're forgetting the social pact that we made in this country with industry back when workers' compensation first came into being in 1911. The advantage is always going to be toward the employee. It's human nature. This is why the commissions, if we can avoid having our workers' compensation subrogation rights litigated or determined within the commission, we do, because it's geared mainly toward the employee. So again, this is just an overview of the history, but generally there is a very, very great need for education and training of judges. And one of the things I wanted to do is take a moment and share with you our website, which hopefully you can see now. This is the home page of our website, and I point this out to you only because I want to point out that if you have an interest in the subject that I've just been talking about, if you scroll down to the bottom, you'll see this section down here, which says Gary Wickert Talks Subrogation on National Radio. If you have an interest, take a look at this, and because it's basically an online debate I had live on the radio, a virtual debate with one of the most anti-subrogation advocates in the country, a professor out of a law school in South Dakota, and this stemmed around the Deborah Shank's ERISA subrogation situation, which gained notoriety, national notoriety, through the Wall Street Journal some years ago, and is very, very interesting. But I also wanted to point out for your information that you're on the homepage now of the Matthiesen, Wickert, and Lehrer website. It's very, if you go to seminars and webinars up here, you can see that we have a whole curriculum of webinars and seminars, just like the one you're listening to today. You can see right here, why I like using the highlighter, I don't know. You can see right here, this is a webinar, the one we gave earlier this spring, that you can actually go to and listen and click on. You just quick sign up, and then you can instantly get access to it, and you can listen to the original webinar that we gave. And as you can see, there's a whole curriculum of webinars here, some others that were recorded that you can listen to, and this one, of course, will be put on here as well. Now, going back to the home page, I wanted to point out some of the resources that we have. We have, well, there's file referral forms here in the event that you would like us to handle any of your subrogation work, but newsletters and published articles are here, and you can click on newsletters and get to almost any subject you have a desire on. The way I like to search, you can see there's just many, many newsletters here with different topics. If you have an interest in something, you can click on Edit, go to Find Page, and search, and it'll pop up. The same thing with published articles. We have all the published articles included in here, organized by general subrogation, workers' compensation subrogation, property subrogation, health and ERISA, auto. They're all located in there. But of most benefit and probably most interest to you is going to be this section here called Insurance Resources, right here. And as you can see, all the way down here, all of these different subjects, economic loss doctrine in all 50 states, comparative negligence laws in all 50 states. These are references that you can go to. Here's a MedPay PIP chart that you can click on, and it pops up, so you can basically see that there's a whole chart there that you can look at and go to when you have the need. So I just wanted to point out that those are available. Those resources are available on our website, and you can go there whenever you'd like. Now, going back to the concept of workers' compensation subrogation, we are really going to be looking at the building blocks of workers' compensation subrogation. These are basically three things that you will not be able to get around. All three of these things are necessary in order for you and your company to have the most successful subrogation program with regard to workers' compensation that is possible. There's three things that are necessary. The building blocks are, number one, early recognition of subrogation. You must recognize subrogation. Those people who are handling the claims must realize that there is subrogation potential, something very easy to do if you're handling a case involving an auto accident and your employee was rear-ended while standing still at a stop sign. That's pretty simple. If your employee is the one doing the rear-ending, it's not quite so simple, but we shouldn't be so quick to assess that there is no subrogation potential. That's a mistake that is commonly made, and it's important to realize that subrogation potential exists out there even in many situations where you don't automatically recognize it. The problem with recognition of subrogation is that we as an industry are somewhat myopic. We are trained to limit liability. We are trained to recognize fraudulent lawsuits and frivolous lawsuits and malingerers and claimants with functional overlay. So we're naturally prejudiced and jaundiced against finding liability. We generally like to assume that claimants create their own injuries and that their own negligence and stupidity and carelessness is what causes injuries. And in many cases that's true. And there's a good deal of contributory negligence that may be associated with those injuries. But the important thing is that we all take off our defense hats. We all take off our claims adjusters' hats, and we put on a second hat. And that hat is one of subrogation. We have to literally become like trial lawyers. No matter how repugnant that concept may seem to you, the laws which exist in this country are there for the benefit of plaintiffs, are still plaintiffs-oriented in many states despite the onset of tort reform. And we, as subrogating carriers, have the obligation not only to our companies and its shareholders, but to the employers, the insureds, the companies we insure and are working for. We have a duty to go out and aggressively pursue subrogation, to recover back their deductibles, recover back their retro payments, to recover back those benefits so that their loss history, their loss modifier, and their risk modifier is kept low, as will their premiums then be in years to come. So early recognition of subrogation is key. And while we won't get into the nuts and bolts of it here, there is, if you remember back to the curriculum I showed you on the website, there is a course called Recognition of Subrogation. And this is a course that is basically a first-year law school torts class, and it walks claims adjusters, experienced and novice, through the various tenets of tort law. It's like a law school, first-year law school torts class, teaching you about negligence, duty, breach of duty, causation, what negligence is, strict liability, auto laws, and really kind of tweaks you a little bit, challenges you to recognize subrogation in cases where it otherwise might not be recognized. One of the things I tell my clients in webinars, and it's the absolute truth, is that the 4 largest recoveries our firm has ever had, and they're all 8 figures and over. The 4 largest, all were cases in which subrogation was overruled. It was written off. The files were closed, or there was something in there that said no subrogation recovery in this case. And either it was later recognized by someone down the road, or we did an in-house file review, which we do for our clients, and discovered some subrogation potential. So the fact that one of the top 4 might be in a case that was closed and marked no subrogation is telling. The fact that all 4 of the top subrogation recovery files were marked no subrogation tells you a startling fact, and that is that we're leaving millions and millions, if not billions of dollars on the table that we're not subrogating effectively. The second building block of workers' compensation subrogation is prompt action. It's one thing to recognize it. And if a claims adjuster recognizes subrogation and then goes about handling the claim, adjusting it, paying the benefits, interacting with the doctors, doing the case management functions, working with Corbell or whatever service you use, that's all well and good. We have an obligation to dutifully and in good faith pay the claim. But if we don't take any action on that recognition of subrogation that we had early on in the case, we might as well not have recognized it at all, because in many cases the subrogation recovery rights become stale, or notice periods may have faded in cases where there's government entities involved, or the plaintiff may have made a recovery and gone on, and without notice under the laws of several states, we are simply out of luck. So we have to have prompt action on subrogation. And it's human nature that no claims handler I know of, nobody from any of our clients, no claims professionals, no supervisors will ever admit that they simply don't have enough to do. Everyone is overworked, because in our industry we are overworked and we're pushed to the maximum. So it's against human nature to recognize subrogation and take action on it when we realize that it may not only increase the amount of work we have to do on any one given claim file, but exponentially increase the amount of work to the point where we may be spending more time on the subrogation aspect of a claim than on the claims handling itself. So our gut is to say, well, no, there's probably nothing here. I'm going to close this one down. And you mark off subrogation as though it doesn't exist and move on. When in fact that's the exact opposite of what we must be doing. So prompt action on subrogation is key. And if necessary, we urge simply the file referral forms I showed you, and I did so with design, on our website. You can refer something to us, ask us to take a look at it, or you can simply down on the left-hand side of the website where I was exploring with you, there's a form there that you can simply fill out with a question you might have, and click send, and usually you get an answer to your subrogation questions no matter the jurisdiction, usually within an hour or two. And that's a good vehicle, a good medium through which to posit a question. Hey, I've got this case, I got a guy who stuck his hand in a punch press that was manufactured in the dark ages. Do I have a subrogation potential? And I can respond back, or whoever answers it will respond back with some additional questions. Well, do you have the product? Have we had an expert look at it? We can kind of coach you through the steps to take in order to more appropriately and adequately fulfill the second building block of workers' compensation subrogation, which is prompt action. So we can help you with that, because we know that quite often it's difficult and you may not know where to turn next, and that's why we're here. Lastly, the last building block of workers' compensation subrogation is aggressive and cost-effective pursuit of subrogation. You've recognized it, you've taken some action to perfect it, you've done the investigation or engaged us to do the investigation for you. Now you must aggressively pursue that subrogation. And what that means is wholly dependent on the state you're involved in and the nature of the claim. Every state is different. And this is what makes workers' compensation subrogation so difficult and so challenging. Your business associations who handle property subrogation basically handle the same body of law no matter which state they're in, with a few minor differences. But with workers' compensation subrogation, you're dealing with 51, including the District of Columbia, 51 different bodies of law, most of which have vastly different and diverse bodies of law dealing with subrogation. So it's very, very difficult to become an expert on all 51 jurisdictions, which is why we urge you to rely on us. If there's subrogation to be pursued, it must be aggressively pursued, but it also must be cost-effectively pursued. And that's perhaps just as challenging, if not more challenging, than recognizing it and taking prompt action on it, because you can't spend yourself into a successful subrogation program. Engaging Matthiesen, Wickert, and Lehrer on every claim isn't going to be the answer, because there are some claims where the liability is so speculative that you have to sort of budget how much time and energy and money and resources you're going to invest. And what you're looking for in those cases, the small cases, no lost time cases, small sub $10,000 medical expense cases where you're going to look for the shortest route between 2 points, the shortest route between the injury and a third-party recovery. And by shortest route, I mean the most cost-effective. So it's very important that we be smart as well as aggressive once we've recognized and taken action on subrogation. Now, the investigation of a workers' compensation claim is, again, a webinar that is a 2-hour webinar unto itself. This is a webinar that we offer. If you go back to the curriculum, you can see that there's an entire webinar, seminar devoted to how to investigate a workers' compensation claim, what steps to take, what things to do, what the differences are in the various states, your timelines, hiring experts, which experts to hire, how to go about doing it. These are complicated things which vary from state to state. But what's interesting is that when you have a workers' compensation claim, and our webinar focuses on investigating the subrogation aspect of the claim, but with regard to just a plain Jane claim, man bends over, picks up heavy object, hurts back while on the job, you're concerned with 3 things. The course and scope. Was he working? Was it the access doctrine? Was he frolicking? You know, every state has different defenses to whether or not somebody was injured in course and scope of employment. And different states have different terms for the umbrage of course and scope. But secondly, you're going to be interested in the extent of the injury. Okay, these are very common things. You now have your claims hat on. And you're going to be looking at possible claims defenses, horseplay, drugs, alcohol, borrowed servant doctrine. Again, this gets into the investigation where there's a lot of overlap between workers' compensation and workers' compensation subrogation. Recently, some of you who receive our newsletter, and by the way, if you don't receive our newsletter, contact Jamie at the email address I gave you earlier, jbreen@mwl-law.com, and she will put you on our newsletter list. But previous newsletters talked about us engaging some of the more prominent and expert workers' compensation defense attorneys in the state to help us, at least with Wisconsin workers' compensation defense. And the reason is because there is a tremendous overlap between the defense and the subrogation aspect of claims. So you're going to be looking at these 3 things when you investigate workers' compensation from the claims side of things. But when you're looking at it from the side of subrogation, there's 3 components. We call them the 3 L's of successful workers' compensation subrogation investigation. You have to be familiar with and understand tort liability. You need to know when the facts in a particular claim will stand up and support a cause of action against a third-party defendant. You have to know if you are in a state that is pure contributory negligence, like Virginia. You have to understand if you're in a pure comparative fault state and how that will be affected if you have a product liability cause of action. You have to understand product liability law, warnings, marketing, marketing defects, manufacturing defects, design defects. You have to understand these components in order to successfully address workers' compensation subrogation and the investigation of that subrogation potential. So understanding tort liability is important, and again, I direct you back to the Recognizing Subrogation webinar that we have. That is a first-year law school torts class that will help you with the first of these 3 L's. The second L is the law. You have to understand subrogation law. This is extremely critical because what your subrogation rights are is key to understanding what you need to do in terms of subrogation and pursuing your rights of workers' compensation subrogation. If you recall back when we were going over the website, and now you realize why I took you on that quick tour, because I'm going to be referring back to various things on that website that I need you to go to if you want more information on some of these subjects. But we have a chart called Workers' Compensation Subrogation in all 50 states. It is a shorthand rendition, a summary, if you will, of the workers' compensation subrogation laws in all 50 states. Now, it is not a thorough treatise, and it is not a substitute for the book Workers' Compensation Subrogation in all 50 states. And by the way, I do not hawk books. Trust me, if you knew what we made on books, you'd know it's not even worth my time to mention the book, other than, obviously, it has some good information in it, and it is a useful resource for you, because the more you understand about your rights and your recovery potential, easier my job is when I finally get involved. But this chart covers a lot of things like which statute governs workers' compensation subrogation in all 50 states and the District of Columbia. Can the carrier sue the third party directly? If so, when and under what time period? There are some states where you're allowed to sue after the statute of limitation runs, which we'll get into later. Can you intervene? Must you intervene? Under what situations can or must you intervene? Can the carrier recover from UM or UIM benefits, and if so, when and how? What about med mal and legal malpractice as third-party sources? Can you recover from them? All kinds of different things are contained on that chart. Now, there's also on the chart, it summarizes the allocation formula for allocation of any third-party recovery, whether employer negligence comes into play. Does the negligence of the employer or the employee reduce your subrogation lien? When and how and under what circumstances can the employee, can the employee's attorney, the plaintiff's attorney, recover attorney's fees? When can he take off a big chunk of your lien and not have to pay it back to you? And how can we avoid that in states where we can? What about the future credit? Sometimes the most important aspect of a workers' compensation subrogation case. When can you subrogate? How much can you subrogate? And do you have to document your subrogation credit with the commission or the courts or anybody in other forms that are needed? What's the statute of limitations for pursuing these things? These are all things that are contained on that chart that help you understand subrogation law, but are not a substitute for the book or consulting subrogation counsel. I warn you about that because there's just no way. Everybody's looking for charts these days, and our website certainly has lots and lots of charts, but I have to warn everybody that the easier and more user-friendly a chart is, the less dependable it is. And that's just the nature of law in our country today. Now, the third L of the successful workers' compensation subrogation is labor. It's in red because it is probably the most important. If you don't understand tort liability, we're here for you. If you don't understand the law, we're here for you. But you eventually, somebody has to take the laboring oar. You have to take the time and use the tools at your disposal to fully uncover, develop, and preserve third-party liability. If you don't do it, no one will. And there is a sort of a vestigial remnant of subrogation practice from the late 70s and early 80s that exists in this country. Years and years ago, and I go more into this on the introduction to workers' compensation subrogation, but years ago we used to sit on our hands. And many of us do today. We take the easy way out. We sit there and don't do any work, and then we're surprised when the plaintiff's attorney is awarded the majority of the recovery or is allowed to gerrymander a settlement such that we don't get our money. We have to recognize something extremely significant in our profession, and that is subrogation is an investment. It is worthy of investing both your time or your talent and your resources into. It's worth taking a look at. I've seen clients not willing to spend $5,000 on an expert to look at potential third-party recovery in a case where they have millions outlaid. And to me, that's penny wise and pound foolish, because one of the 4 largest recoveries we've ever had is a case where I asked it happened to be Lloyd's of London, I asked them to take a close look and invest $25,000 in the hydrologist on a very significant 8-figure loss. And they finally agreed to, and we uncovered some things that eventually led to recovering 8 figures on a major, major property loss. And so subrogation is an investment, and it is worth the time and the money to explore. At the very least, at the minimum, it's worth filling out one of those subrogation question forms on the Matthiesen, Wickert, and Lehrer website and clicking send, depicting a couple of facts, giving us some background, and then asking whether we think there's any subrogation potential. I can promise you we're not going to be soliciting subrogation cases where there isn't any subrogation potential. That would be counterproductive and counterintuitive for us as a private law firm who serves as plaintiff's lawyers for the insurance industry, which is basically what we do. We talk about putting on your plaintiff's hat. I, for example, have been a member of the American Association of Justice, the former ATLA, the Association of Trial Lawyers of America, since November 9th, 1983. This is the premier plaintiffs organization. Defense lawyers aren't allowed. They're not even allowed to use the website. If you are a plaintiff's trial lawyer and belong to the AAJ, you have access to all of their databases. You have access to their publication forum, for which I regularly submit articles on how to create liability, because you don't want defense lawyers handling your subrogation. Their job, their expertise, their training is in limiting liability. It's finding ways to shortcut and get you out of lawsuits. And on the other hand, subrogation is really a plaintiff's profession. So we look at ourselves as trial lawyers, plaintiff's lawyers for the insurance industry. But my point being that being a member of the AAJ, we really do put on the plaintiff's hat and look at things from the plaintiff's perspective. So now that we understand the 3 L's, we're going to talk about analyzing workers' compensation subrogation. We're going to look at 5 basic questions that you should ask yourselves on every claim. And if you train yourselves to answer these questions for every workers' compensation claim you have, you can rest assured that 95 to 98% of the subrogation potential which passes your way under your nose, previously perhaps undetected in many cases, you will recognize. You will have the ability to and make the conscious decision to take prompt action on subrogation you recognize. If you don't recognize it, if you don't ask yourself these questions, you won't be making the right decisions to maximize subrogation. So subrogation is easy if you're okay with leaving millions of dollars and billions in some cases on the table. It's really a gutless choice if you simply sit back and every time you have third-party subrogation potential, you send out a notice letter and then completely dismiss the subrogation aspect of a claim from your mind thereafter. But once you recognize that a third party may be responsible, the reason subrogation is so difficult is because we have 51 jurisdictions. The law is always changing. You are the party crasher. You are the one who is not welcome. Neither the defense lawyer nor the plaintiff's lawyer nor any of the parties in the lawsuit want you there because you are there to skim money off the top, money that's statutorily yours, your company's, the shareholders of your company. You're insured. It's their money. They deserve it. And you are there to crash the party and claim that money. So the plaintiffs and defendants will often conspire to defeat your rights. And sometimes even judges and ALJs will, part and parcel, do what they can to give the money to the plaintiff because you're simply the rich insurance company. And you don't need the money, and they do. Well, if you believe that, you'll probably understand why some companies have been troubled in our industry, why we have receiverships, why we have companies that go under. You realize, a quick story, I was flying from, I practiced in Houston, Texas for 20 years and had the same national practice there that I have here. And I was traveling to Dallas to speak to Employers Casualty Company. They had a company-wide, nationwide gathering. They had several thousand people in the big auditorium in the basement or in the first floor of their building. And they were having an all-day seminar on how to improve their product. And my subject was workers' compensation subrogation at the time. I also spoke on property, but I was there first and foremost to speak on workers' compensation subrogation. And on the plane, I opened up the business page and I noticed that the headlines on the Houston Chronicle business page said, "Employers' Casualty Seized by Regulators." I was already in the air. And I'm thinking, oh, great. Now what? What kind of an audience am I going to have with 2,000 people filling this audience, listening to my voice reverberate throughout the large room talking about subrogation? They're going to be worried about their jobs. What are they going to do for their pension? How they're going to pay for G.I. Joe with the Kung Fu grip for their kids. They're worried about everything except what I was there to talk about. But you know what? I had the most attentive audience that day because I realized, or they realized for the first time, that anything and everything they could do to help their company survive might mean that they had a job in the future. And it was during that seminar that we uncovered the fact that some of them were not taking credits in the appropriate fashion. And that might have been accounted for some money which was left on the table. Excuse me for 1 minute. Okay, so you are the party crasher, and there is no substitute for education, information, and experience. And we're covering education and information here, the experience you either have or will have. Now, we're going to answer 5 questions for workers' compensation subrogation. These 5 questions, first and foremost, are in this order. What are your subrogation rights? Which third parties can be sued? Are you talking about a UN carrier? Can you sue a doctor? Can you sue a lawyer? Can you sue the co-employee, as the laws in one of our states were just changed to announce that you can sue a co-employee, period. How is a recovery allocated? Very important. Once the money comes down, who gets what? And what happens if the plaintiff's attorney and the defendant gerrymander a case to give it all to the wife for loss of consortium, or give it all to the kids who perhaps aren't beneficiaries? Are attorney's fees and costs owed, and if so, in what formula? And last, and perhaps sometimes most important, do we get a future credit? You have to know the answers to these questions in order to maximize the recovery. And the answers to each of these questions is not the same for any 2 claims, because in every state the law is different, and in every claim the facts are different. And so it's really one of the most challenging areas of subrogation that we can be in. Now, question 1. As you remember, we look back at these 5 questions. The first question, what are your subrogation rights? Question 1 depends totally on the statute. What are your subrogation rights? Well, it depends. In California, there are 15 different statutes that govern your subrogation rights. Maybe this explains part of the reason why California is in such trouble. They take 15 different statutes to cover what your subrogation rights are, when other states take just 1 paragraph. It covers 8 pages of our book in the California chapter. Massachusetts, on the other hand, is a very short and simple statute, which is a little amazing because Massachusetts is not known for its lack of legislation. But we have to ask ourselves what our subrogation rights are. There's oftentimes an election by the worker. Years ago, the election of the worker, the employee, had to make an election. Does he or she recover comp, or do they pursue the third party in tort? And for many years, they had to make a choice. Those choices are all virtually eliminated now, and you can pursue both simultaneously, but that the vestiges of that election having to be made by the worker still exist. You want to know who can bring the third party action. Can the plaintiff's attorney bring the action at any time before the statute of limitation runs, or does the comp carrier, you, the subrogated carrier, have the right to bring the action at any point during that running of the statute of limitations? We'll go over a few states here in just a minute and go through some examples of that. We want to also know, when can a third party action be brought? There are time limits. There are restrictions. There are timetables set forth that are different in every state that govern when a third party action can be brought. We want to know that. Why? Why don't we simply sit back and wait until right before the statute of limitation runs? Because it's the easy way out, and we don't have to invest anything in it. Well, the answer is going to be clear by the time we're done with this webinar. It's because maximizing our recovery means taking advantage of the laws that we have before us. If we have the right to bring a third-party action and there's only $25,000 in policy limits, I want that whole $25,000. I don't want you giving up 2/3 of it or all of it because we missed a deadline, because we didn't intervene, because we didn't provide notice. These are important things that we have to be looking at. And by the way, the the plaintiff's attorney is not going to be your friend. It is almost never advisable to call up the plaintiff's attorney and ask him to protect your interests. First of all, in almost every state, that's a blatant conflict of interest. How can he protect you and maximize the recovery for his client? Because you guys are fighting over a limited slice of the pie, almost always. The answer is he can't. And what happens is, yeah, sure, we'll cover you, because he wants to get your fee, to claim a fee from you. In some states, you're not allowed to take a fee. He's not allowed to take a fee. But the bottom line is that almost always when push comes to shove and there's a limited amount of money on the table, he's going to call you up and he's going to tell you how bad his case is. He's going to tell you how his witnesses have kind of moved down to Mexico or moved abroad, or they can't be located, or they've died, how the case suddenly is not any good, the same case he was raving about earlier when you asked him to represent you. So it's almost never a good idea, because if subrogation is our religion, as subrogation professionals, if subrogation is our religion, the plaintiff's attorneys are atheists, and they cannot be converted, no matter what is at stake. It is against their nature, and quite candidly, it is against their called profession to represent the injured worker, to give recognition to or not fight against or work to destroy your subrogation rights. They're simply atheists when it comes to the religion of subrogation. There's a quick story I like to tell about an atheist who was taking a walk through the woods, and he noted what majestic trees and what powerful rivers, what beautiful animals, he was saying to himself. And as he continued to walk alongside the river, he heard this rustling in the bushes, and he turned and saw a 10-foot grizzly bear standing on his hind legs, dropping down and starting to charge him. He ran as fast as he could up the path and looked frantically over his shoulder like in the horror movies, kept falling down, but he saw that the bear was closing in on him. There was no way of escaping. His heart was pumping frantically, and he tried to run even faster. He tripped again and fell on the ground and rolled over to pick himself up, but saw that the bear was right upon him, raising his paw, ready to take his final swipe. And at that instant, the atheist cried out, "Oh my God!" Time stopped. The bear froze, and the forest was silent. It was then that a bright light shone down from the heavens, and a man and a voice shone down upon the man, and a voice came out of the sky, and he said, "You deny my existence for all these years. You teach others I don't exist, and even credit creation to a cosmic accident. You expect me to help you out of this predicament now by crying out, 'Oh my God.' Am I to count you as a believer?" the voice said. The atheist shielded his eyes and looked up at the bright light. And after a moment, he said, "It would be hypocritical of me to," and he stammered, "it would be hypocritical of me to suddenly for you to treat me as a Christian now, but perhaps you could make the bear a Christian." After a slight pause, the deep voice said, "Very well." The light went out, and the sounds of the forest resumed. Immediately he looked at the bear. The bear lowered his paw, bowed his head, and spoke, "Lord, bless this food which I'm about to receive, for which I am truly thankful. Amen." The bottom line and the moral of the story is that the plaintiffs are atheists. No matter how tough it gets, you will not get them to believe in third-party rights. So understanding your subrogation rights, know when a third-party action can be brought. It's important to know these things because you cannot rely on the plaintiff's attorney. Do you have a right of intervention? In some states you can intervene. In some states you can't intervene. And in some states you must intervene or you lose your rights. Do you have a statutory lien? There are states like Wisconsin which simply say, there are cases which say there is no such thing as workers' compensation subrogation. There is merely a right to get back your money and get it all back. You don't have to subrogate or be subject to equitable defenses to subrogation. You have a statutory lien. Are your rights lost if they're not protected in the suit? If you know about a pending third-party action and do nothing about it, you don't hire us or other counsel to intervene and represent your interests, are your rights lost? Do you lose the ability to take a future credit? The answer in some states is yes, in some states it's no, and in some states it depends. Now we're going to look at some examples of state statutes that govern this very first question. Remember the 5 questions? The first one is, what are your subrogation rights? In the state of Alabama, A worker can pursue workers' compensation and a third-party action simultaneously. The carrier has a lien on third-party recovery. But interestingly, the carrier has 6 months after the statute of limitation runs to file suit. And we have several clients that ask us to come in and do in-house file reviews, both open and closed files, some electronically, some hard copies of files. We always walk away with subrogation potential that has been overlooked. That's not a slight on the employees there. It's simply a fact that this is all we do. I could no longer adequately and competently adjust a workers' compensation claim and deal with the bill review people and the claimants and the doctors and the bill collectors. I'm not trained to do that, but we are trained to recognize and aggressively pursue subrogation. So we've walked in and looked at closed files involving cases in Alabama and had to inform our client that, look, even though the statute of limitations is run and these are in closed files, you still have a right to recover. And the beautiful thing about this is the plaintiff's attorney does not have a right. The carrier cannot file on its own before the statute of limitation runs, which is really a hard concept to get your mind around. But the carrier may intervene into a third-party action filed by the worker if it can show it can make a substantial contribution to the suit. And we can always show that. We've had a lot of experience in convincing the judges that we can make that contribution. And most often the plaintiff's attorneys are eager to have us involved because we're another good lawyer head involved, and sometimes we offer to help assist with costs and things because our job is not only to maximize recovery, but sometimes to make the third-party case look more attractive for the plaintiff's attorney. The worker can't intervene into the carrier's suit. Isn't that interesting? So after the statute of limitation runs, we have carte blanche. We have the right to recover and file suit against the third party, and the worker doesn't. And what makes this clever is we can work out deals where no third-party suit is filed. We can call the third-party tortfeasor and say, hey, I'll make you a deal. I won't tip off the employee to the fact that he has a good third-party action here if, when the statute of limitation runs, he'll agree to deal with me in settling this case. And of course, he better, because we can still file suit even after the statute runs. And lastly, the carrier can recover both past and future payments if it's the one filing suit. Now, why would you want to file suit? In some cases, you wouldn't. But in many cases, you will, because you're going to be the one who wants to get out there first. And if sometimes the plaintiff, the injured worker, is dilatory and negligent in looking at its rights. Maybe he doesn't believe in lawsuits. Maybe he's afraid that somehow the lawsuit will piss off the employer. Maybe the employer's talked to him, and the third party, who is ultimately liable and clearly liable, is a good client of the employer. This happens quite often. So you will be the one who wants to file the third-party action. This is, and what's interesting is I had a judge from Mobile, Alabama call us recently regarding some issues, and we referred him to our website, and this judge was just amazed, and there were some things he even told us that he wasn't aware of, that he wasn't implementing in making decisions in his court. So it was just a stark example of how badly education is needed. Now, Wisconsin. Wisconsin is, without a doubt, the most favorable statute in the U.S. for workers' compensation subrogation. Texas used to be a close second. Back in 2005, they had some tort reform that went into play that now brings the employer in a little bit. Arizona's a good statute. California, despite the fact that it has like a gazillion sections of their act that deal with this, and it's very complicated, can be a good state once you have a recovery. But there are other problems in California we can talk about. But in Wisconsin, you've got the most favorable statute. The carrier or the worker, either one, may file a third-party suit. Both have an equal voice in prosecution of the suit. And notice must be given by either party to the other if you're the one filing suit. Now, why does this make such sense? Again, now we see why I went through a little bit of the history, because the social pact that America made with labor, with the employers, with small business, was, look, you may be on the hook for millions of dollars, but we're going to give you the right to recover your money back. And so Wisconsin is the most favorable statute for workers' compensation subrogation. It was also the first statute, and it's most favorably because it does hold true to that social pact. It holds up its end of the bargain, whereas many states do not. In Wisconsin, both parties have 3 years to bring their third-party action. The worker can intervene after the statute of limitations has run if the carrier has filed suit. We just saw in Alabama you can't do that. So we can't make the same deal in Wisconsin that we talked about making with the third party in Alabama. But again, in Wisconsin, we don't need to. So you can see how these are just two states we've looked at, and already we can see how varied and diverse the law is and how complicated it can be, which is why we urge that you rely on subrogation counsel to get us involved in some aspect of your claim, recognizing subrogation, and certainly taking action. Now, a carrier may intervene into a third-party action unequivocally. In fact, we have to, because in Wisconsin, the subrogated party must be made a party, and we have to file an answer, a subrogated cross-claim, and a subrogated counterclaim in order to protect your workers' compensation subrogation rights, whether it's $500 or $500,000. Wisconsin requires you to be part of the litigation. If you know there's litigation going on in Wisconsin and you are not part of it, there is a problem. It may not be your problem, but it might be. So if you know about that, please give us a call. Lastly, the carrier can recover both past and future payments, just like we saw in Alabama. Now, I want to just take a note. Now, we've only touched on 2 states, and only 2 states with regard to one of the 5 questions that we have to ask. Well, we can already see how different the states are. We're going to discuss extraterritorial subrogation in a little while. This is the situation where you may have a lawsuit filed in Illinois, but benefits may be paid under Wisconsin. So it might be possible to argue around and avoid the not so favorable Illinois workers' compensation subrogation laws, but employ the Wisconsin section 10229 to that Illinois lawsuit. Well, how can that be? Why would they follow Illinois law? The answer is conflicts of laws. We'll get into it in a little while, but it's important to know that if you are familiar with your options, especially early on, you can really trump and preempt the plaintiff's attorney because we have a big advantage. We're involved in the cases much sooner than they are. Now, the second question is third-party liability. We want to know who can be sued. This is the second of the 5 questions. Who can be sued? And it's important, an important question because in order to take prompt action, you have to know who you can take prompt action against. Now, I mentioned that investigation and recognizing third-party liability legally is a subject of another webinar that we offer. But recognizing the liability of the third-party tortfeasor is key in the second of these 5 questions. We know that the employers are generally granted the exclusive remedy and are protected via the exclusive remedy. So almost always the employer is going to be immune from suit, and this varies from state to state, but in some cases they can be brought in if there is an intentional act. Excuse me for a second, I'm grabbing a drink of water. So the exclusive remedy rule is that social pact that we made with the employers. It's part of the deal. Look, employer, you're not going to be sued. You're not going to be sued because you, even where you're not at fault, have to be on the hook for millions of dollars in medical expenses, and that's a costly, costly endeavor. So we're going to hold you harmless. We're going to say that the employee can sue a third party, but he can't sue you. Well, what does that mean? Who can be sued? The exclusive remedy rule sometimes can be gotten around if there's an intentional act or gross negligence. And remember that if the employer has a contract with a third party, then that contract may indemnify, the employer may indemnify the third party, so the tortfeasor that you can legitimately pursue The tortfeasor, the plaintiff, can pursue, may have a right to come back against the employer based on contract, and whatever damages are held against the tortfeasor will ultimately be paid by the employer. That is often, and most often, I think there's only a few exceptions, allowed, so the employer can be gotten to if it contracts for liability. But without contracting for liability, without indemnity, generally the employer is held harmless and immune. Now, we have some rather wacko states that seem to forget about the social pact that we have, and one of those is Illinois and the other is Minnesota. Minnesota and Illinois, and especially Illinois, allow contribution actions against the employer in which a third party, if it feels that the employer might have been contributorily at fault, and of course, when are they not going to think that? So you'll always see the employer brought in, can be brought in for third-party liability. We'll talk a little bit more about this later, but the fact is that employers can be brought in some states, but generally they're exempt. So who can be sued? What about the co-employee? Well, generally, again, now we have 51 different bodies of law, and the law is different in each state, and there are some states which say an employee can be brought in if he suddenly steps out of his managerial capacity and moves into more of a co-employee capacity, assuming specific duties owed and then breaches those duties. It gets rather complicated, but by and large, co-employees are immune along with the employer. Now, there are exceptions. There are exceptions when a co-employee intentionally injures somebody. If a co-employee walks up to your injured worker and slugs him, cold cocks him from behind, chances are that you're going to be able to pursue that co-employee. But again, where does that get you? If he's judgment-proof, has no insurance for an intentional act, are you just getting a paper judgment? These are all things that have to be rolled into the cost-effective aspect of workers' compensation subrogation. Missouri, brand new case just came out. It'll be in our next newsletter. So today is August 10th, and the newsletter will be coming out in the next week. And that newsletter will contain an article about a brand new Missouri Court of Appeals decision which says, wait for it, co-employees can be sued, period. What? Yes, co-employees can now be sued in Missouri. It doesn't matter whether their acts are intentional, negligent, careless, or whether they simply left something lay and another employee fell over it. The exclusive remedy rule is a little bit turned on its head here. Missouri has forgotten, at least the legislature has forgotten about the social pact we made, and you can sue co-employees, which is good for us because in some cases co-employees may have assets. In some cases, co-employees may have homeowners policies which may cover if it's merely a negligent act. So there may be sources of recovery that we've previously overlooked in Missouri that now we can't pursue. What about a UM-UIM carrier? Well, the law on this is different depending on which states you're in. If you go back to the workers' compensation subrogation chart, which I pointed out earlier in the webinar on the website, there is a column there that says, can you recover UM-UIM benefits? For example, in Alabama, you cannot. Alaska is undecided. In Arkansas, you can do so only if it's the employer's policy. In California, you cannot. In Delaware, you can if it's the employer's policy. In Indiana, you can with the employer's policy. In Maine, the answer is yes. In Kansas, it's only to the substituted payment made by the UM carrier. In Louisiana, you can subrogate against the employer's policy only unless the UM policy excludes benefits to the workers' compensation carrier. In Michigan, you can for UM coverage, but cannot for UIM coverage. In Montana, the answer is yes. In Nebraska, the answer is yes, but possibly only applies to employer's policy. In New Hampshire, the answer is yes. In New York, the answer is no. North Dakota is undecided. Ohio has said thumbs up to it. Oklahoma has said thumbs down. In Pennsylvania, the employer can subrogate to UM-UIM benefits. The employee cannot. So we can subrogate, the carrier can subrogate to the UIM policy of the employer, not to that of the employee, but if it's the UIM policy of anyone else, they can. So you can see, in Vermont, You can subrogate to UIM benefits, but only if the plaintiff is made whole, even though the whole made whole issue doesn't apply to subrogation as a whole. So you can see how complicated this becomes. At every turn, there are a dozen questions that can be answered a dozen different ways in a dozen different states. So knowing whether or not you can subrogate against UIM benefits is extremely beneficial, because if you have a case involving minimum limits, let's say you have $50,000 limits from the third party and your lien is $50,000, you can then go to the plaintiff and say, look, I'll take the $50,000 because you can go after the UIM carrier, whereas we cannot if you're in a state that can't. Or if you're in a state that can, you can be a little more generous in solving the third party limits of the third party, because you know you have the right to recover from the UIM benefits that are left over. What about a subcontractor? There is an article and a chart that is also found on our website called Workers' Compensation Subrogation in Construction Settings. In many states, in an effort to protect employees, the construction industry is notorious for independent contractors not having workers' compensation subrogation, and because workers were being left without coverage, many states started saying, well, we're just going to hold that if the subcontractor doesn't provide workers' compensation insurance coverage for its injured employee, then the general contractor or even the owner will have to step up and provide that workers' compensation coverage, even though the injured worker wasn't an employee of theirs. So they are considered an implied or statutory employer. And the law goes on to say then that we're also going to protect that general contractor or that owner if they have to step up and provide workers' compensation coverage. Other states are going to protect them even if they don't have to step up and provide the coverage, but merely because they would have had to. They're considered statutory employers, and it's important to know whether or not you can recover from them. Again, medical malpractice and legal malpractice, it all depends on the state. Whether or not you can subrogate against med mal, the majority of states do not allow it. The majority of states do allow it. The med mal you can recover in Alabama, Arizona, Connecticut, Florida, Delaware, Idaho, Illinois, Indiana. You can't in Iowa and a few other states. But legal malpractice is a little different. The majority of states do not allow you to subrogate against legal mal, but in some cases you can. Alaska allows you to do it. Several states like Arkansas, California, Colorado, undecided. Believe it or not, it's still undecided whether you can subrogate against legal mal. So if you have cases in those situations and the dollars are there, you may want to pursue it, because you may make the law like someone else did in other states that changes the law. Florida you cannot, Delaware you cannot. So again, understanding what third-party liability you can pursue and what third-party liability you cannot pursue is critical. Let's look at a few examples of state statutes here. In Utah, the employer is immune, period. The parent corporation of employer is also protected. The co-employee is immune, unlike the Missouri state case which just came down. The co-employee cannot be sued unless there is an intentional act. The carrier is not subrogated to UIM recoveries, and the carrier is not subrogated to legal malpractice judgments or settlements. However, legal malpractice judgments or settlements, but the carrier is subrogated to medical malpractice subrogation recoveries. Now compare that with the state of Indiana, where employers and co-employees are immune, even if the act is intentional. But note that in Indiana, the exception for an intentional act is not set forth in their statute, but it's by equitable subrogation under common law, which is going to be totally missed if you simply pull out the statute and read it. So this is why education is key, and it's going to be very difficult for everyone to retain all of this. You will have the PowerPoint. If you happen to be viewing this webinar through the website as a replay or a recorded version of this webinar, you may want to get a hold of Jamie Breen at jbreen, J-B-R-E-E-N, at mwl-law.com and ask her for a copy of the PowerPoint, and she can send that to you so you can follow along and make notes on it. But the carrier is subrogated to UIM policies because in Indiana, remember these statutes say if some other party, if some third person or other person is responsible for the injury, then the worker can sue that other person and recover money back, but has to repay the comp carrier. You know, that's the general boilerplate. But in the Indiana statute, the UIM policy is considered, quote unquote, an other person. Carrier is also subrogated to medical malpractice, but it's undecided if the carrier is subrogated to legal malpractice in the state of Indiana. Now, understand that Indiana also allows for a non-party to be sued for contribution. So while the employer is immune, as they are in most states, a growing number of states are now allowing a non-party to be sued for contribution. And that's code for the employer. Because a non-party, first of all, any lawyer who files a personal injury suit and doesn't sue all the people responsible is committing gross malpractice. So most attorneys are not going to leave out parties that are responsible. So any non-party who is left out of the plaintiff's lawsuit is almost always going to be the employer or a co-employee. So, but these non-parties, the employer can be sued for contribution by the defendants in a case within 45 days before the statute of limitations expires. Now, what's important is, and there's a quick story about a case I'm handling in New York. Injury happened in Indiana. A guy was working in a foundry making steel coils, and this he was working with a giant crane that had a hook, and the hook was hooked onto this giant steel coil, and he was lowering the coil, and it caught an edge of the stand where he was going to stand this 5,000-pound coil, and it fell on the employee. Well, the allegation was that the hook was defective because the employer remodified the hook such that it would not fall off even if the cable became slack. Well, we sued the negligent defendant in New York because that's where the defendant was located. That's where they made the hook. And after several years of litigation, the hook manufacturer filed a motion to have Indiana law apply because they realized, hey, in New York, you can bring in a non-party, you can sue the employer for contribution, but only if there is a grave injury, and grave injury is defined rather specifically in the statute, such this particular injury, as grave as it was, didn't qualify as a quote-unquote grave injury under that statute. So the courts finally ruled that Indiana law would apply, and I was representing the workers' compensation carrier, and years in advance I had recognized this potential of Indiana law applying. But there's something else in Indiana that comes along with the rest of their workers' compensation statute, and that is something called the Indiana lien reduction statute. Well, I did not want to face the Indiana lien reduction statute because this was a tough case, and chances are, as it turned out, this case settled last month, by the way, after 7 years of litigation, as it turned out, the plaintiff recovered less than the quote-unquote full value of his case. So what I did is, early in the case, back when we were hot and heavy in New York law and nobody was even thinking about Indiana law, I entered into a stipulation with the plaintiff's attorney that ended up saving our behinds because had the lien reduction statute applied, we would have lost the majority of our lien. So that's a good example of Indiana law. Now, California. California is the statute, is the case, as you can see, it has 15 different statutes that govern workers' compensation subrogation. Couldn't have just one, they've got 15. I showed you, again, here's why I went through our website. If you go back to the website where I showed you the newsletters and go to the May 2009 newsletter, there are two very, very useful articles there in that newsletter dealing with California workers' compensation subrogation. It's a special edition. One of them is called Understanding Future Credits in California Workers' Compensation Subrogation. The other is called Intervening in California Workers' Compensation Subrogation. And it's important because in California, either the carrier or the claimant can file suit, which is great. But the carrier has three choices. This is what makes knowledge important. Education is the key. And without knowledge, we're doomed to condemn ourselves to less than full recoveries, or in many cases, no recovery at all. Again, remember, the investment that subrogation represents. It's real important to remember that in California, because you have a choice. You can either bring the action directly as the comp carrier, you can join as a party plaintiff, you can intervene and join into the suit and help prosecute it, you can allow the plaintiff, or you can sit back and allow the plaintiff to prosecute the suit on its own, his or her own, and then later when he makes a recovery, urge a lien. Now, in order to do so, you can do so in one of three ways. You can file a notice of lien. This is where the intervention is not cost effective, and it has the same effect as simply giving written notice, or you can just give written notice. But the problem is that if you, with these three options, the first one's the most expensive because you now have to prosecute the case. Chances are the plaintiff will intervene in, but that gives you a leg up on whether or not you're going to be ready if the plaintiff settles around you later on. Or you can join as a party plaintiff. You can intervene and be active in the case. And I recommend at a minimum joining as a party plaintiff. The reason is this. No matter which of the three you do, I mean, if you're bringing the suit on your own, that's fine. The plaintiff can intervene, and then later the plaintiff can settle the suit on his own, because in California, the plaintiff can settle around the carrier for some reason. It doesn't give you a statutory first right of reimbursement. It allows the plaintiff to settle for those elements of damages which don't represent your medical expenses, past and future, don't represent lost wages, and sort of leave you standing out in the cold. The problem is, if you're not, if the case is at all complicated, if the case involves some rather obtuse factual situations, and you're not ready, you haven't participated, you haven't attended the depositions, you haven't been up to speed, you are not going to be ready to try the lawsuit. And they often settle right on the courthouse steps, so you basically have to step into their shoes and try that lawsuit. So my recommendation is to join as a party plaintiff, always. Not simply do a notice of lien, unless the lien is under $10,000 and the case is somewhat speculative. Doesn't look like it's a good case. And don't always rely just on your own judgment on whether or not it's a good case. I would rely on the plaintiff's attorney, his initial impressions of the case, and subrogation counsel. But my recommendation is join as a party plaintiff and have your level of involvement be commensurate with the combination of the size of your lien, the prospect of future recovery, and the viability of the case. If the case is an extremely untenable case against the state of California, in which the burden is just horrible, and by the way, we just made a nice $4 million recovery against the state of California, the county of Alameda, and the city of Hayward, California, for some inverse condemnation causes of action, and made a nice subrogation recovery for our client. But it wasn't easy. So join as a party plaintiff and be very active if it's a large lien and the case is relatively good. Be a little less active if the lien is smaller and the case is less good. And all the way down to if the case is under $10,000, file a notice of lien. These are rules of thumb. There may be cases in which you'll want to be a little more active in a case under $10,000 because that's all the money there is, and you're going to want to get that money. But the bottom line is these are some of the issues that have to be addressed in California, and those two articles I mentioned that are on our website under the May of 2009 newsletter will help you in understanding your options when it comes to California. Now, California has a rather complex credit issue, and it's really rather complicated in that there is a credit threshold that has to be overcome. Almost always in California, someone is going to allege the employer is negligent. If you have a $1 million third-party recovery and the employer is found 50% at fault, that doesn't wipe out your lien automatically, but it does create a situation where you now have to take 50% of the $1 million for $500,000, and your lien gets eaten up, and then your credit gets eaten into, and it's a situation where you don't get a credit for the reduced credit amount. You basically have to continue paying into the future unless and until your credit threshold is met, and then you can start taking your credit. Rather than go through it in detail here, I would direct you to the Navigating the Storm article that's found on our website, and You can also look at the Understanding Future Credit Issues in California Workers' Compensation Subrogation article found in the May 2009 newsletter. And the employer's credit threshold, again, is discussed there in a great amount of detail. So employer contribution now becomes a big issue when you're talking about this second question of who you can sue. There's another article in the March 2009 newsletter on our website called Contribution Against Employers in Illinois Workers' Compensation Subrogation Cases. Very, very good case. And a quick story just to tell you how, don't assume that everybody knows the law. If you come off as knowing the law, even plaintiff's attorneys will have to admit they don't. We recently mediated a very large case in Illinois, and we were in a room filled with the best and the biggest law firms in Chicago, 2 of the best trial lawyers, and 3 of the biggest, most expensive defense firms there. The conference room was filled with people, and the question came into how do we deal with the contribution action, because in Illinois, contribution action against the employer can mean unlimited liability unless there's a Kentucky cap, which means that the contribution against the employer is capped by the amount of the lien, but that cap can be waived, and almost always is these days. But the whole scheme flustered everyone from the experienced mediator to all the experienced trial attorneys, and the only people in that room who understood and explained to the room how it worked were us, the subrogation counsel. And it just goes to show that if you have the knowledge, you can write the script. And knowing the knowledge up front, as we'll see later on in extraterritorial subrogation, means you can make some decisions which really will benefit you later on. Just like the story I told you about the New York, Indiana case, where I knew up front that Indiana law, if it applied, could prove problematical, so we worked toward a stipulation. That caught everybody by surprise. And after the case was resolved, and after Illinois law was held to apply, the plaintiff's attorney was kicking himself because he realized now he could have gotten rid of $1.7 million lien in a work comp case where he was going to end up having to settle for $1.5 million. Think about that. So employer contribution. In Minnesota and Illinois, you have Kentucky contribution in Illinois and Lambertson contribution in Minnesota. Again, these are states who have forgotten the social pact we made and are allowing the employer to be brought in, and in the case of Illinois, even possibly responsible for fresh money owed in cases. And I won't go into too much detail on that, but understand that that's a possibility. In Alaska, contributions allowed against the employer only if the employer is found 100% at fault. In Arizona, California, Kansas, and Texas, there is a proportionate reduction of your lien if there is a verdict, and that verdict holds the employer responsible for some percentage of fault. In Idaho, contribution bars subrogation altogether, and the lien then offsets the recovery. So in other words, the recovery is reduced by the percentage of the employer's negligence. In New York, as I mentioned earlier, contribution only if there's a grave injury, and in Utah, you can only recover contribution against the employer if the employer is 40% or more at fault. The chess game that goes on because of the variety of laws we're dealing with here is just absolutely astounding. And I've played chess ever since I was 5 years old, and my story is, while I don't play quite as much as I used to, when I was 13, I was playing in the Wisconsin Open. For those of you who enjoy chess, chess ratings by the United States Chess Federation, or FIDE, F-I-D-E, generally run from about 1,200, 1,100, which is really a good chess player by all common standards, but not competitive, up to Bobby Fischer, who was mid-2,700 rating, and Gary Kasparov, who was one of the highest rated chess players of all time in the mid-2,800s, who later went on to become the mayor of some Russian city. So I enjoy chess, and I enjoy the chess game that exists in these workers' compensation subrogation cases. In Utah, this means that you can put a lot of emphasis on defending the employer when you think that there's a chance you can hold contribution under 40%. So how the lawsuit is tried is another reason to have local counsel involved. I can guarantee you what happens is the plaintiff goes in and settles the case, and then wants to have a quick little side trial to the judge on what kind of negligence the employer had. Well, all of the witnesses he brings in and everything he does, and all the witnesses fall on the sword, dumping on the employer, because they know if the employer is found 50% fault, 50% of the lien goes away. Excuse me for 1 second. Sorry, it was time for a drink. So understand that in Utah, as in all 50 states and all 51 jurisdictions, understanding employer contribution is key. Now we get to the third question, and this is the money question. Now, we've gone past all of the other stuff. If we worked hard on questions 1 and 2, we get to a third-party recovery, and we now have the pleasure and the commensurate chore of allocating that third-party recovery. And this is when the plaintiff's attorney becomes the atheist. This is when all of his goody two-shoes, buddy-buddy talk, all of his promises, his grandeur, his description of how great a case it was start to fall on their ear. Because this question deals with how and when does the carrier recover its lien. Now you have certain states where there's formulas. We'll go through a couple examples. You have other states where they're entitled to first money. You have other states like Georgia where they're entitled to first money, but they can't recover a penny unless and until the claimant is made whole. And of course, when does that happen? You have other states that sound like they have great statutes, but at the end they have a equitable reduction clause or some clause that says the court can make a judicial determination or allocation based on a number of facts. And one of those facts generally is, well, how much has the plaintiff recovered, and has he recovered all of his damages? So we have to really be on the lookout now for the erosion of the pact that was made with the employers and us, the carriers who insure them. And again, this is why we talked about the history. But does the carrier recover past and future payments? There are a few states in which we are to recover the past benefits and the future payments. We get a check for those amounts, or we don't recover them at all because there is no future credit. Is there a special formula used, and is that formula inviolate? Is it carved in stone? Can we tell the plaintiff's attorney, we'll just email him a copy of it and say, here's how you allocate the recovery, without him coming up with any fancy, well, let's just do a third, and a third split of a third-party recovery, which, by the way, if you're listening to this seminar, you carry anything away from the seminar, never, ever do a third, and a third recovery in a workers' compensation subrogation case. It's so easy to do because we tend to just go, well, it's found money. I didn't have the money before, and a third of is better than nothing. Well, you know what? You have a statutory right to this lien. We're going to talk about how strong these liens are in just a bit. Insist on your money. If you have to allocate minimum limits, if you have to agree to compromise somewhat, don't do a third, and a third. Do 75%, 25%, or worse, 60-40. You have the strength. The odds are in your favor. The law is in your favor. And the judge generally will support you because he has to. Does the employer's negligence reduce the recovery? We talked about this earlier. Will the Made Whole Doctrine be applied? Are you subrogated to all elements of damages? There are some states that say you, the work comp carrier, yes, you have a lien on the case, but you only have a lien on those elements of damages recovered in the third-party case that represent special damages, that represent consequential damages such as medical expenses, lost wages. These are the simple damages. These are the cornerstone of any personal injury case. You're subrogated to those, so if the plaintiff settles and suddenly allocates all of the recovery to pain and suffering, mental anguish, and things of that nature, you have the problem of economic versus non-economic damages. If you're only subrogated to economic damages, medical expenses, lost wages, and the plaintiff's attorney is saying the whole recovery is non-economic damages, you have a bit of a problem. And there are some states in which you can go to the court and contest this. There are some states in which you cannot. You then have to be ready to go against the third party to recover the economic damages. And this all goes back to the investment. The investment. Why it's so important that you're active in the case. Why it's so important that the judge, the plaintiff's attorney, the defense attorney know that you have counsel on the case that is capable, knowledgeable, is board certified. I'm triple board certified, twice by the Texas Board of Legal Specialization, Personal Injury and Civil Trial Law, once by the National Board of Civil Trial Advocacy in civil trial law. Why is that a big deal? Because I want everyone out there in every case I'm involved in to know that I am capable of trying a lawsuit, that I was taught to try lawsuits by one of the best trial lawyers in the country back when I started working out in practicing law in Houston. I want them to know that so that they don't feel emboldened to try and slip a quick one by us to settle for non-economic damages, thinking that we might just go away or crater or accept just pennies on the dollar. I want them to know that they're going to have two large settlements, not just one. So these are important. Now we can look at some examples of state statutes. Again, this is the third question. We're asking about allocation of third-party recovery. In Arizona, one of the most favorable states for workers' compensation subrogation, the carrier has a lien on any recovery. And in Arizona, they avoid one of the problems that we see quite regularly. You get a third-party case where there's minimum limits of $25,000. You have a lien of $18,000. The plaintiff settles for $25,000, and rather than paying you $18,000, he says, well, I'm giving the injured worker only $10,000 of that $25,000 recovery. 15 of it's going to the wife or to the husband if it was a woman who was injured. And therefore, only $10,000 of the recovery is subject to your lien because generally, we are subrogated only to the amounts recovered by the beneficiaries, the injured worker, in a death case, the kids, the wife who get the recovery, not other beneficiaries under a wrongful death or survival act statute in a particular case. But Arizona has said that your rights, your lien on any recovery extends even to loss of consortium. So right away, there's no way they can gerrymander a settlement, at least using that tool in Arizona. The carrier's lien is reduced by a proportionate share of the employer's negligence, but this is only if there's a jury verdict, not a settlement. And the carrier, as in many states, has the right to challenge that percentage. And nobody wants to have that challenge because that means a hearing. So we can challenge whatever gerrymandering efforts the plaintiff's attorney tries to put in front of us. We also have the right to approve and disapprove of any settlement, and the carrier does not act in bad faith by refusing to approve a settlement. So good statute in Arizona, as we'll find out later. I'll give you a little spoiler alert here when we get to attorney's fees, which is the fourth question. Arizona does not allow recovery of attorney's fees. That's good. Okay, Georgia. All right, this is the hellhole of subrogation in America. The Made Whole Doctrine is actually codified into the statute itself. Contribution is not considered with regard to whether or not an injured worker has been made whole. In addition, you must request a special verdict. So in Georgia, you have to be involved in the case. You have a Georgia workers' compensation lien. You want to know whether or not to intervene, whether or not to take action, what your strategy in this chess game is going to be. The answer is you must intervene. You must be active, because if you're not, you're just inviting them to gerrymander a settlement and allege that the worker is not made whole. And I can tell you that I have never, in my 27 years of experience, had a plaintiff's attorney in Georgia turn to me and say, you know what, I think my worker has been made whole. You're welcome to your lien. It just doesn't happen. So a court hearing may be required, but the burden of proof is on us. Now, I want to point out that, again, we went to the website. If you go to the January 2009 newsletter, there's an article in there called Georgia Workers' Compensation Subrogation Primer. This is a complimentary booklet which we originally did for a client doing a lot of work in Georgia, and we are now sharing it with you for free. It is a article in a booklet. Literally, it's a booklet. It's that long, which goes through the nuts and bolts of Georgia workers' compensation subrogation, the strategies, the laws, how to prove you made whole, how to avoid this sort of stuff, why you have to be involved. In addition, in Georgia, there is no subrogation if the benefits are paid in a foreign state. This is important to remember. When you get a first notice of injury, let's say the injury is in Texas and it's a Georgia employer, and the worker calls you up, or the employer, and says, okay, we need to start benefits. We're going to do Georgia benefits or Texas benefits. Go with Georgia benefits. Because if the accident happens in Georgia, let's say, and the lawsuit's going to be filed in Georgia, you do not have subrogation rights if you pay Texas benefits. I can tell you that this is a clear mistake made by the Georgia Court of Appeals. They misread the law, but that's what we're dealing with, and we go more into that when we discuss Georgia, and there's more about that in that pamphlet. So Georgia subrogation, there's no subrogation rights if benefits are paid under a foreign state. Now, with regard to evaluating, and by the way, knowing the state law regarding allocation, this is important because it helps you determine how likely you are to recovery, and it helps you make an informed decision on how to handle workers' compensation subrogation. So, when you're evaluating workers' compensation subrogation files, now we're still on question 3, but I'm going to insert this here because it's important, because we all have to make these decisions. You have to evaluate workers' compensation subrogation and make a decision on how it's going to be handled, understanding that it's an investment, it's a chess game, but you can't spend yourself into successful subrogation recovery. So you look at the comparative fault. Is the state one of comparative fault or pure contributory negligence? If you're in Virginia or North Carolina or one of the other states where you have pure contrib, meaning that if the plaintiff is 1% at fault, he doesn't recover, he or she, then you have to take that into account, that full recovery may be less likely, and adjust your chess moves accordingly. You look at the state where the suit is to be filed. That's important because ultimately the law of the state where the suit is to be filed will determine the subrogation law, which state's subrogation law will be applied. We'll talk more about that in a minute too. You look at the cost and fee structure. You want to refer a subrogation file to Matthiesen Wickert. You want the correct fee structure. Now, we work on both contingent fees and hourly fees. We work on blended fees. A lot of times if there's investigation, one of the things we'll do is we'll work on an hourly fee on cases where it merits it to do some investigation, and then we'll switch to a contingency once suit's filed or we recognize third-party subrogation, but we'll give you full credit for any hourly fees billed. You want to look at likely costs and experts' fees. A $10,000 products case isn't likely a very profitable one to pursue because the experts' fees may cost you more than the lien itself. However, we do something called networking, where we work with plaintiffs' attorneys around the country, and if I can refer that case, the same case where all I can recover for you is $10,000 because that's our lien, but he can recover $100,000, then he might be more willing to spend money on an expert, and we can then ride on the coattails. And if we refer it to him, a lot of times we can get a stipulation. Stipulation which says you will take this case, we're referring it to you, but in exchange you agree to repay the workers' compensation carrier. You also want the correct subrogation strategy. This is very, very clearly important in states like California and Illinois and Georgia. You file a notice of lien. Don't fall for the easy and, pardon me, but somewhat gutless choice of simply saying I'm going to file a notice of lien because it's cheap and my lien is going to be protected. You may have the right chess move in that case might be to file an intervention. It might be to prosecute independently. It almost always involves at least consulting with subrogation counsel. Keep in mind that our interests and your interests are aligned. If it's not in my best interests to prosecute a case independently, it's also not going to be in your best interest. Now, while that sounds selfish, it just happens to be the way it works out. If it's more advantageous for us to file a notice of lien, and I'm working on a contingency, I will make that recommendation. If I think there's chances that we're going to get poured out because the plaintiff's going to settle around us in states like California, I won't make that recommendation. In fact, we will instruct our local counsel to prosecute aggressively. And this is just a word, too. Matthiesen, Wickert, and Lehrer handle subrogation files in all 50 states. We do so through a bevy of local counsel that we've had since 1983. There's 265 sets of local counsel that we have large contracts signed with, and these contracts govern everything they do meticulously because we are not a file forwarding firm. Like some companies out there, we simply don't take your files and then email everybody and say, anybody know a good subrogation lawyer in Boise, Idaho? We don't do that. We have subrogation counsel, many of whom we have trained and follow our procedures, and they do precisely what we tell them to do, and more importantly, don't do what we tell them not to do. They are boots on the ground. They don't simply run and handle the file. We explain to them what to do. We do the briefing. We send the briefs and the research to them because we have the expertise. They don't. It's simply not possible to write a letter or an email to a listserv and say, is there good subrogation counsel in Gainesville, Florida? Well, I can count on one hand the number of good subrogation counsel. There are good lawyers, but that means they're good defense lawyers who happen to do subrogation. They have a lot of integrity. They're nice guys. They're good to work with, but understanding the details, the nuances, the microcosms of workers' compensation subrogation or subrogation in any genre, property, auto, medpay, PIP, fidelity, surety bonds, fire, casualty. It's important that that experience be shared and disseminated, and we'll call it the trickle-down theory of subrogation, because the expertise and the experience and the research, you don't get invented. It's not like they're reinventing the wheel. It simply trickles down from us to local counsel, and we instruct them what to do. They are our boots on the ground. That's just a short little blurb about how we operate nationally in all 50 states. Now, important to realize, too, that in evaluating subrogation files, whether or not you hire subrogation counsel is a key decision, which brings us to the fourth question. We've now handled 3. What are your subrogation rights? Who can be sued? How is any money allocated? And fourth, what about attorney's fees and costs? Can the plaintiff's attorney recover fees? Under what circumstances? Can the plaintiff's attorney recover costs? What's the formula? Many states have formulas that apply not to allocating a recovery, but to allocating costs. And knowing those formulas up front and being active in the case can often reduce or totally eliminate fees and costs recovered by plaintiff's attorneys. And in some states, even allow us, wait for it, even allow us to recover costs and fees from the plaintiff's attorney. That means that the plaintiff's attorney, high and mighty, has a 40% contingency, recovers $1 million, has a $400,000 fee coming, earned every penny of it, right? We have in some states, and this is true in Wisconsin, if we're aggressive enough, the right to go to the court and say, I want some of that $400,000. What does that mean? That means that money comes to you. And there's nothing better than to confuse my clients by sending them money and they don't know exactly which debit column to put it in, because it's above and beyond the amount of their lien. So 100% recovery is a goal. Anything above 100% is a bonus. But we're all about making sure that every case and every opportunity, we have the ability and the potential to recover that bonus. Can you recover fees based only on the past? Can the plaintiff's attorney recover fees based only on the past lien? Or can he recover fees based on future benefit payments? And that, like in Illinois, where you have contribution and the attorney's fees in Illinois don't simply get paid up front, but as each and every payment after a third-party case settles, each and every benefit payment continues from the workers' compensation carrier. We owe 25% of those benefit payments as a fee, and that money gets paid to the claimant. Interestingly, it does not get paid to the attorney because the attorney has already received his fees. On $1 million recovery, he received $400,000 fee, or 40%. So we are reimbursing with every payment, every indemnity payment, every medical payment. This is Illinois. 25% of those payments goes to the plaintiff to reimburse him, compensate him for the fees that he's had to pay. Which costs can be recovered from the carrier? Now that's interesting. We want to know exactly which costs can be recovered, and we always want to look at the costs that the plaintiff's attorney is alleging, because oftentimes you'll see things in there that aren't appropriate, like advances to his client. Well, that's just double dipping. So we want to look at those. What if the carrier has active subrogation counsel? Now, there's some statutes, examples of statutes that we can look at. In Arizona, as we mentioned, no attorney's fees are owed at all. In Arkansas, the carrier must intervene. In California, the court may apportion costs and fees if the carrier is actively represented. Another benefit, another consideration to go into when you're doing that chess move analysis in the state of California. In Colorado, if the carrier acts on its own, it can't recover fees. In most other states, you can. In Illinois, as we mentioned, you can have a pro rata recovery of fees or owing fees up to 25% max. In Tennessee, if there's active participation, fees are owed. In Wisconsin, there's a formula followed, so no fees are owed at all. Another reason why it's one of the most favorable subrogation statutes, or the most favorable in the country. Now, a typical third-party distribution, I'm going to use Texas law for an example. Let's assume a $10,000 lien because we want to grade ourselves. We want to know how well we're doing in the case of a third-party recovery. If we have a $90,000 gross recovery, $30,000 are taken off. Let's say the plaintiff's attorney is on a 1/3 recovery. If he's on 40%, the numbers will change. That leaves a $60,000 net recovery minus our lien, $6,667. Well, what is that? I thought we had a $10,000 lien. Well, it's $10,000 minus 1/3 for the fee. That leaves a $53,333 net recovery for the plaintiff. That amount is our credit. Now, there's an argument that we have and we use in the appropriate cases that our credit should be the gross recovery, meaning it should be the $90,000. But for sake of argument, this is how it's normally calculated. And to the right, we can see our credit card. P for plaintiff, he recovers $53,000. The insurance company, that's us, recovers $6,700 plus a $53,000 credit. And the attorney gets $30,000 in fees. That totals $90,000. So recovery of attorney's fees by the carrier is a concept that we get into because statutes that provide that the carrier be a portion part of the fee if it is joined in pressing the action, like Wisconsin and Texas, give us the opportunity to be active in a case and then hit the plaintiff's attorney for allocating part of the fees. In other words, he claims, well, you owe 1/3 of your lien. I'm going to reduce it by 1/3. Whoa, 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 not so fast. You can go and apply for that 1/3 in states like Texas, but only if we don't show that we were active and actively participated in the case. And if we actively participate in states like Texas, the judge must, underline must, apportion that lien. Whether it's $1 to us and the balance to the plaintiff's attorney, doesn't matter. He must apportion it if we actively participate. So the court must also allocate some fees to the insurance company when the subrogation attorney participates actively in the case. And attorney's fees recovered means 100% recovery by the carrier, because if you're giving away a 1/3 of your lien, you're not making a full recovery. So part of the battle isn't just getting all of your lien less the fee that's owed, and it's not simply letting the plaintiff's attorney run amok with your subrogation interest or your right of reimbursement. It's aggressively protecting all aspects of your lien. Now, one of the arguments that we make, and it's so common that you'll have a lien, case will settle, all of a sudden you'll get a letter from the plaintiff's attorney, or he'll call you and say, look, my guy wasn't made whole, I'm apportioning all of the money to the mother, the wife is getting most of it, the kids are getting it, we think the employer was negligent, we don't think you are owed anything, but I'll give you $5,000 to make you go away. Well, on a $50,000 lien, $5,000 isn't a whole lot of money. So one of the things that we have been successful in is that the ethics rules in all states indicate that if a plaintiff's attorney has in any way, shape, or form promised to protect your lien or represent you, send us that file and we'll get 100% of your money back, because they have an ethical obligation to do so. They can't suddenly turn against one of their clients for the sake of the other. But where plaintiff's attorneys try to argue that they are entitled to a lien after they have tried everything in the book to destroy your lien, we've been very successful in arguing to the court that, look, the equity in this case doesn't bear out the fact that the plaintiff's attorney should recover fees. He's tried everything possible to cheat us out of our money and make sure we get nothing. And because he wasn't good enough, smart enough, or creative enough, clever enough to do so, he now wants a fee? Well, that's absurd. And we've had some very good success. We'll take a look at a few examples of fees recovered by a carrier. Under Wisconsin law, if the carrier prosecutes the case on its own, here's how we do the report card. $90,000 recovery. We get fees apportioned. As you can see, $30,000 in fees, 20 goes to the plaintiff, and 10 we are successful in getting the judge to award to us. We just did this recently. That means the $60,000 net recovery is reduced by 1/3 to the plaintiff. This is following the Wisconsin formula. $40,000 is subject to the lien. minus $10,000, the carrier gets reimbursed in full, which leaves $30,000 net recovery to the plaintiff, which is our credit. So in this case, the plaintiff only gets $50,000. The insurance company gets $20,000 plus a $30,000 credit, and the plaintiff's attorney gets only $20,000. Finally, it's a little bit more like it should be. The plaintiff is winning, insurance company is a close second, and the plaintiff's attorney is a distant third. If the carrier prosecutes the third-party action alone under Wisconsin law, we see that the $90,000 recovery is reduced by fees to the insurance company, and that net recovery of $60,000 is reduced by the formula, 1/3 to the plaintiff, which does not constitute a credit. That's free and clear. So he has a hurdle now. He can spend $20,000 on whatever he wants, Las Vegas, slot machines, and it doesn't eat into his credit. Leaves $40,000 subject to the lien. Carrier is reimbursed $10,000. Leaves a net recovery to the plaintiff of $30,000, which is our credit. Now the report card reads the plaintiff's attorney gets $30,000, the insurance company gets $40,000 plus a $30,000 credit, and the plaintiff's attorney gets nothing because he is not in the picture. And something important to remember, there are many, many cases where the plaintiff's attorney should not be in the picture, and we do not hesitate to tell them that, and they do not like hearing it. For example, clear liability case, plaintiff injured, he's got $100,000 lien, but there's $25,000 limits. Well, there's no reason to hire a plaintiff's attorney. If there's no UM coverage, and the plaintiff's attorney should look at the case and say, look, Mr. Client, the workers' compensation carrier is going to get the $25,000. There's really nothing I can do for you here other than take 1/3 of it as a fee. So he's now the party crasher. He's the intermeddler. He's the one stepping in and not increasing the recovery because all it took was a demand letter to get the $25,000, but yet he's recovering the fee. So what about future credits or offsets? We go back and we look at the questions that we had asked, and one of the last question after attorney's fees and costs is, do we get a future credit? And quite often this is more important than recovery of the lien. In some cases, the lien, especially in death cases where the lien grows slowly but there's huge, huge reserves, getting a future credit is more important and often requires different chess moves to protect than does protecting the lien. So we can look at some examples here. In Connecticut, for example, there is no credit. You must recover the future payments out of the recovery. Georgia, there just simply is no future credit. Another example of how this state has forgotten the pact that was made when workers' compensation came into being. In Texas, you get a credit for the entire net recovery by the worker, but again, I have an argument for the entire recovery period, and we can use that successfully to barter. And in Wisconsin, the formula says fees come off the top, 1/3 goes to the worker, which doesn't constitute a credit. The balance goes to the carrier, and if there's any left, it constitutes a credit and goes to the plaintiff. It's important to document your credit with the commission. Again, I'm going to refer you to the website. There's an article, there's a chart entitled Documenting Workers' Compensation Statutory Future Credits in All 50 States. It's very important that you visit this. In Wisconsin, to get your credits, you must file a specific form with a specific agency, or you do not get your credit. Now, the truth is that most of the time, because plaintiff's attorneys don't know this stuff, most of the time, they're not going to be able to challenge your right to a credit because they don't know that you were supposed to file something or what you were supposed to file or who you were supposed to file it with. But it's important that we know, because in some states there are specific things, and the best practice is to get something filed, get it documented. If you ever settle your workers' compensation claim, make sure to reserve the right, your statutory right of subrogation and reimbursement, and right to a future credit, because there are some states that have tricky laws that say you can waive that. Now let's look at, under credits and advances, let's look at the purpose and function generally is to make sure that the carrier, after a third-party recovery, can stop having to pay benefits. Because the plaintiff has now been made a millionaire, the workers' compensation carrier should stop having to pay benefits and workers' compensation indemnity and medical benefits. What generally happens is the claims handler will one day be working on a claims file that's haunted him or her for months and years, and the claimant is always calling, where's my check? Check's in the mail. A real pain in the rear end, and suddenly one day you don't get any calls, and you don't get any calls for a couple of weeks. And you call up the claimant, what's happening? Why aren't you calling me? Oh, I made a nice third-party recovery. I'm rich now. I don't, you know, you can send them whenever you want. Well, bells should go off in your head, obviously, that somewhere there's been a recovery and you missed out. Likewise, if you ever get a subpoena, any subpoenas for your comp file from anybody, send to us. It's real simple. There is something going on that you need to be a part of, a vital part of, and you're missing out, and money is being lost. It's being left on the table. Credit is often more important than the lien itself. If you fail to properly document it, it does happen. Somewhere along the line, a creative plaintiff's attorney will claim you're not entitled to your credit. Every state applies a credit differently. And in some cases, you can have waivers of subrogation. Another important topic that we talk about in our chapter in our book called Contractual Limitations to Subrogation. And if you have a waiver of your lien, oftentimes, as in Texas, and I argued this case to the Texas Court of Appeals, there's also a commensurate waiver of your credit, but that's not always the case. When you settle a third-party case, you want to watch out for allocation of damages. You want to make sure that there are some states in which future credits are awarded based on the amount of future lost wages that are awarded by the court or by the jury, by the judge, and you want to be in on that. Another consideration for your chess game when you're deciding whether you're going to take the shortcut out, which is almost always garbage in, garbage out. You get what you pay for. If you take the shortcut, file a notice of lien, send out notice letters, and sit back and wait, you almost always, it's going to be more expensive in the long run than had you been involved with both feet in the game. It's almost like playing a chess game without the queen and the rooks. You're going to need to aggressively pursue your case in order to maximize your subrogation recovery in most cases. So you want to have the proper documentation. You want to have the proper form. These are a couple examples of a typical calculation. $120,000 settlement, less 40% attorney's fees, means an $80,000 net recovery, less $30,000 lien reimbursement. Generally, the net recovery of $50,000 to the worker constitutes the future credit. Here's some tips dealing with credit. And we could have a webinar unto itself just dealing with future credits, especially when you get involved in cases like California and Illinois. In fact, I think that's a great idea. We're gonna probably do a webinar all on its own dealing with future credits because it certainly merits it. Do not sign a release unless it preserves your right to a future credit, your right to reimbursement. Be careful when settling work comp claims. You want to be specific about past liens, future credits, totals, and outstanding bills. What I mean by this is, let's say you're in mediation and you have a $50,000 lien, and the case settles for $250,000, and out of your $50,000 lien, you recover $35,000 for some reason. It should be $50,000, but let's say you receive $35,000. Everybody goes home from the mediation, and a month later, you're wondering why the settlement hasn't been funded, and it's because there's checks coming in from Zurich, Switzerland, and you have to have approvals, and there's release language and indemnity clauses and releases that's being negotiated, and maybe there's a minor, and you have to have a minor settlement, or there's an MSA that has to be done. Could be any of these things that's dragging out a settlement. Meanwhile, the clock is ticking. You've got $35,000 supposedly being paid to you out of your $50,000 lien, but in the weeks and months that tick by, you're paying more medical. You have more medical bills coming in. You have more claims for benefits. You have more every week. There's another indemnity payment that goes out. So when you're settling a case, be very specific. Ladies and gentlemen, my lien is $50,000. I want $50,000 back out of this lien. If we don't get the money tomorrow, which I know is not going to happen, that lien might grow. You have two choices. The lien can grow, and I will tell you what the lien amount is when this case is finally funded, the settlement is funded, or I will take every bill, whether it was incurred prior to the date of the settlement or after the date of the settlement, whether it's been paid or it's currently sitting on my desk back at my office waiting to be paid, and those will all be sent to Mr. Plaintiff All you'll owe us is $50,000, but you're going to owe for all other benefits incurred, because a lot of times before mediation, when the plaintiff's attorney thinks it's going to be successful, what does he tell his client to do? Go out and quick get that surgery. Go out and quick do this, quick do that. Let's get this benefit paid, thinking that somehow those bills won't come in until after the case is settled. So be careful. Watch out for gerrymandering, when that means money is being allocated to parties who aren't beneficiaries and to whom you're not subrogated, and always, always, always document your credit with the appropriate commission or agency. The chart we've given you contains, on the website, contains an appendix which has actual forms from the regulations and the commission's rules with regard to best case, best recommended case for settling. Now, here's a couple examples of calculations. In Alabama, for example, and this is again why this is such a complicated area of subrogation. Alabama allocates something called the Miller formula. This is an example of a very complicated credit system. The Miller formula looks at the elements of damages allocated by the court. They calculate the net recovery to the worker, divide the net recovery by the value of the case. That gives you a fraction. You multiply the actual future benefits that are going to be owed by the fraction, and you get something called the gross future medical expense credit. You reduce the gross future medical expense credit by the carrier's pro rata share of attorney's fees. This is something called the Fitch formula, which is basically the net future medical expense credit. And then you take that fraction and you have to document your credit and file it on a form WC4. So you can actually calculate it using this very arbitrary determination of what's the value of the third-party case. The fraction in this Miller formula is an arbitrary number. So that's why being involved, again, here's the chess strategy. Being involved from the start allows you to be involved in picking that denominator, which can drastically affect the amount of recovery you make. Now in Wisconsin, it's a little more straightforward. $900,000 settlement, $300,000 in attorney's fees, $600,000 net recovery. Under the formula, a third goes to the worker. It doesn't constitute a credit. $400,000 net recovery gets reduced by the past lien, and we have a future cushion of $150,000. That's pretty straightforward. But you have to file and document your credit on a form WKC 170. Again, that's in that chart that's on the website. Now you go to Florida. Again, more complicated. Florida follows something called the Manfredo formula. This applies any time there is no full recovery by the plaintiff. And when is that? Altogether? Always. Always. They claim that there is not a full recovery. So the Manfredo formula is you take a ratio of the net settlement to the full value of the case, but the difference in Florida is that the full value must be judicially determined. The court determines the full value of the case, then the carrier reduces the future benefits by this percentage. You have to file form DFS F2WC, DWC4 if there is no court approval of the settlement, and that's in cases where there is like a settlement. Now in Georgia, the statute reads, insurer's recovery under this section shall be limited to the recovery of the amount of benefits paid. What does that mean? Sadly, and quite simply, no future credit. And again, we talked about the fact that in Georgia, if benefits weren't paid under Georgia law, you do not have subrogation rights. In Illinois, I'll go through Illinois rather quickly because we talked a little bit about it, but in Illinois, the employer's liability for contribution is something that mucks up the social pact, again, that we created in workers' compensation. You have to subrogation and are limited to past, lien, and future liability. In other words, the employer's liability for contribution is a function of the percentage of fault that is found on the employer. And generally, the employer is liable only up to the amount of the past lien and the future liability. So you take the past lien, take the reserves, and that's the limit of its liability. So basically, if the plaintiff is a zillion% at fault, it doesn't owe a bunch of money when the Kentucky cap is in place. It simply is limited to the past lien and future benefits. So it waives its lien and just walks away, essentially. But the Kentucky cap can be waived, and it's most often waived in AIA contracts and other construction contracts. And the language in which effectuates a Kentucky cap waiver is quite varied and it's quite a minefield. So what happens if there's a waiver of the Kentucky cap, then suddenly the liability of the employer isn't limited to the past lien and future benefits. It's unlimited. But there's good news. First of all, the defendant, what happens is the defendant pays the verdict, then seeks contribution from the employer. That's how it works. But in practice, there's generally just a calculation made, and the money is just evened out. The employer contributes pro rata to the defendant, and fresh money liability is a possibility. In other words, because the carrier owes a certain percentage to the defendant and pays in that percentage, it then gets that same amount reimbursed from the plaintiff, which is kind of a wash, but it owes 25% attorney's fees. So essentially, there's 25% fresh money liability to the employer in many situations. The Lefevre versus Chemlite case is one that's important. The Illinois Supreme Court said this. Because it's so complicated in Illinois, we have the big advantage. Don't run scared in Illinois. Stand up boldly, go down swinging, because even where the employer is negligent, you have the advantage. This is the chess game here. You have the advantage of taking back a move in chess parlance. Because if the jury comes back and finds a whole lot of negligence on the employer, Lefevre versus Chemlite, the Illinois Supreme Court says you can simply waive your lien and walk away after the fact. You get to find out what the winning lottery numbers are, and then go buy your lottery numbers. And so it's really good. And you know, there is a need often for employer defense counsel in Illinois cases, but never let employer's defense counsel also represent your subrogation needs. They'll say they can do it because oftentimes that's where the money is, in taking a percentage of the subrogation interest, but in truth, there's a direct conflict. Now, the future credit in Illinois, again, you get 75% of present cash value paid to the carrier. Future benefits are paid at a rate of 25%, and a lot of states are like that. In Indiana, on the other hand, statute reads, when there's a third-party settlement, the liability of the carrier to pay further compensation shall terminate. What does that mean? It means that if there's a third-party settlement, there's simply no obligation to pay anything further, but it doesn't really mean that. Surprise, surprise. The Indiana Court of Appeals, again, forgetting the compact that was made, the social compact made with employers and through extension with the carriers, they said that there is no credit when the recovery is before an award and the recovery is less than the anticipated benefits. So there's a little twist there. In Iowa, the subrogation statute does not provide for a credit when the worker prosecutes the third-party action. It allows the carrier to take a credit when the carrier prosecutes the third-party action. Important to remember. The court also reads certain credit rights in the 8522, although they're not set forth in there. So don't let the plaintiff's attorney tell you you're not entitled to it. A warning, you must file a notice of lien. Warning, if you settle a third-party case, Section 8535, settle a contested work comp claim, it literally bars your right under 8522 to subrogation and credit. So be very careful and make sure that language and the agreement is spelled out in there. Again, California, we talked a little bit about this, so I'm going to gloss over this because I think it's going to be more functional for you to actually go and read the article that I referenced to you about California. Under 3858, the carrier gets a credit for any net recovery, except in malpractice cases, medical malpractice. And if there is no employer negligence, you simply take your credit. If there is employer negligence, you have to file a petition for your credit. And guess what? There's always employer negligence because they're going to allege there's always employer negligence because they want to reduce your lien and your right to a credit. So again, you have the three choices. When a third-party case settles in California, you can recover your lien and enter into a compromise and release of the compensation claim. All right? Very simple. Or you can recover your past lien in a stipulated credit amount. Or the plaintiff, and you don't agree on everything, he contests everything, and a trial court determines the employer negligence percentage in a trial and then decides the lien reimbursement and credit amount. Now, if the case settles, the trial court is out of the picture, and the Workers' Compensation Appeals Board gets in the way, and that's not a good option for us because they're always going to side with the employee. The threshold of employer negligence I talked about, quick example, it's $1 million verdict times 20% employer negligence equals $200,000. This means the lien is reduced by the amount of the employer's negligence. Next, the credit is reduced by the employer's negligence, and you must meet the employer's threshold before it gets either. There's a common mistake. Attorneys will tell you if there's employer negligence, there's no credit. That's simply not true. Your credit is delayed, however, until the amount of future benefits you pay out equal the percentage of negligence that the employer has. So the $200,000 amount in the example above, let's say your lien is 100. Now that 200 is reduced to 100 because you waived your lien because of the employer negligence. But now you have to pay $100,000 in future credits. And once you do that, then you can start taking your vacation. And it's best to calculate that and document it. And if the plaintiff's attorney disagrees with your calculations, go get a hearing on it. Quick California hypothetical, $340,000 third-party settlement reduced by the lien means a $194 net recovery to the worker. If there's 25% employer negligence and you have a $500,000 value of the third-party case, you have the following situation. The employer's threshold is $125,000. That's $500,000 times 25% for its negligence. Its future credit is $69,000. That's $194,000 net recovery minus the $125,000 difference. Now the the carrier's credit is delayed until the threshold is met. The carrier has to contribute an additional $125,000 before it can start claiming a credit. The goal, reach a stipulation with the plaintiff's attorney. Whether you have a settlement or a jury verdict makes a big difference because the total tort damage determination has to be decided as well as the employer negligence. Rule California, if you see the word California in your claim, you got to hire subrogation counsel. It's that simple because the plaintiff can and will settle around you if you're just resting on your thumbs. If you're sitting back and not treating it with the right investment strategy, you haven't taken time to look forward to the chess moves that are necessary, he will settle around you. So credit summary in all states, it varies. Every state is different. Know the law. When you're in doubt, always document your credit. No one's subrogation counsel involvement will save or increase the recovery. Check with us if you have questions. Be aware of the problem states that we've discussed. Be aware of a waiver of a past lien to close out a pending compensation claim. There's something else that gets involved here, and that's the subject of MSAs. And we'll talk about that here because we're going to talk about other workers' compensation issues. And we have issues of discovery. When you're working on your file, you want to protect your claim file as a subrogation professional. The minute you think there's subrogation, mark it in your file, whatever date it is, even if it's day one. There's subrogation potential here. I'm going to be investigating for purposes of an anticipated third-party action we plan to file, period. Maybe it's not true. Maybe you really think there isn't subrogation. But if you actually write that in your claim file, then you won't have a problem. And that file will then be protected because when the defendant tries to subpoena your file, when the plaintiff tries to subpoena your file, then we can step in and say, no, everything after that date, the date you wrote that in your file, is protected as work product privilege. Experts, product liability law. You want to hire experts, but you want the right expert. Be careful in your work comp cases. When you go out and hire an expert, the same experts you hire in every case, chances are he's not an expert. There are some states that follow Daubert and other gatekeeper laws which prevent you from using just anybody. You want to have the right expert. So we've taken the time over the last 27 years to gather over 25,000 experts in all different disciplines, organized by discipline, organized by geography, in other words, what state they're in, and organized by cost, which is important because you have Ford, you have Hyundai, and you have Porsche experts. You have experts for the cheap cases, you have experts for the middle-of-the-road cases, and then you have the expensive experts that you want and need on the cases involving the larger damages where credentials really matter. You hire subrogation counsel or intervene. We talked about that. rely on us because, again, if it's necessary for subrogation counsel, we will let you know. Conversion of subrogation monies, what happens when you have this all-powerful lien? The statute says you get your money. The plaintiff's attorney apparently hasn't read the statute and says, no, I'm not going to give you your money. Well, the options are different in all 50 states. In some states, you can go against the plaintiff. You can go against the plaintiff's attorney. You can go against the defendant. You can go against the defendant's liability carrier. So you have a lot of stroke. But notice is necessary, and if there are some states where you haven't gotten counsel involved, where you haven't filed an intervention, where you haven't filed an answer, where you haven't filed a notice of lien, you could be out in the cold, which is why, again, we have these webinars so that you learn and know what to do. Settlement when the claim is open, we talked about. Borrowed servant doctrine, again, when you're doing your investigation, when you're gathering those pebbles of information and putting them in your saddlebag, you want to know and help and to anticipate future borrowed servant arguments, because not only is this a defense possibly to excuse me, the underlying work comp claim, maybe there's someone else who should be on the hook for these benefits, but it also can be a defense to the underlying third-party case. Excuse me, I had to get a drink. Dual Capacity Doctrine, knowing if a defendant is also a manufacturer of a product. Many states allow you to sue an employer even though he's the employer because he also helped manufacture a product or a process. Indemnity, we talked about how even an employer can be brought in even where he's immune. We talked about construction litigation, and we'll talk briefly about that. But I want to just talk briefly about MSAs. This month, and this month is August, there is an article in the Subrogator that we wrote on, I don't even remember what it's called, but it's about MSAs and the role that MSAs play in workers' compensation, subrogation, and settlement of third-party cases. The Center for Medicare has now opened up liability, potential liability, for even possible secondary payer liability when you settle third-party cases. So it's real important that that we analyze the possibility that an MSA is needed. One of the things we're doing in states where comp claims can be settled, like Illinois, for $1, you can do a dollar contract, but in exchange for the dollar contract, we're saying in some cases, look, the carrier will fund the MSA because neither party is very comfortable with the fact that an MSA might not be there. We'll fund the MSA, but we get that money back off the top as part of our lien, and we'll fund it in exchange for the dollar contract. And that actually works out very well because the plaintiff, believe me, the plaintiff's attorneys are just as confused as to future MSA liability. By the way, NAST has asked me to do a webinar on MSAs, and I'm in the process of getting back with them on that. Also remember the Chinese wall when you have employer liability, when you have states in which the employer can be brought in for contribution, you must keep the claims people away from the subrogation people. You do not want claims folk who are handling the defense of the employer to be working with the subrogation people because states deal with this differently, and you don't want bad faith allegations to haunt you. In workers' compensation settings, we talked briefly about the fact that you have waivers of subrogation and statutory employer status where contractors and owners, general contractors, may be liable for workers' compensation benefits. I referred you to the article in the newsletter about workers' compensation subrogating in construction settings. There's a chart that goes through the law. That's a great place for you to start. But understand that there are some states now like Nevada, and Texas is coming into its own now, where you have owner-controlled insurance programs or wraparound policies where the general contractor says, okay, everybody give me your bids. Here's all the bids. Now I want you to back out all the money you put in there, which was to pay for workers' comp premiums and liability insurance, because I, the general contractor, am going to provide all of the policies which cover everyone. Well, again, forgetting the social pact made with employers, these states like Nevada and now Texas to some extent are holding these owner-controlled insurance programs, OCIPs, or contractor-controlled insurance programs, CCIPs, these wraparound policy programs, they're holding that everybody who's part of that program is considered to be a statutory employer and is immune. Nevada has a rather complex scenario with regard to this, and we even had to author and copyright a chart in our Nevada chapter in our book which says that. But again, look for the handout for the summary of this law in all 50 states, which you'll find on the website. Now, real quickly, extraterritorial subrogation I mentioned earlier. You may have situations where injuries occur in one state and the lawsuit is filed in that state, but benefits are paid under the laws of another state. Extraterritorial subrogation is basically any effort to subrogate outside the boundaries of the state where the benefits are being paid. So if you're paying Texas benefits, but the lawsuit is filed in Georgia, Texas is the enabling state. And this is more common than 20 years ago. We have an interstate practice economy now more than we did. We have a national and a global economy. And we are primarily concerned with extraterritorial subrogation. We're concerned about which states' subrogation laws apply, the enabling states or the forum state. So in the example I gave you, where you have Texas paying benefits, lawsuit filed in Georgia, the enabling state is Texas, the forum state is Georgia. So you have 50 states, and this provides just a plethora of different potential opportunities or situations where one state's law may apply, workers' compensation laws may apply to a lawsuit filed in another state. And as in the Indiana example I gave you, this can work to our benefit. So when you have comp claims involving multiple states, you have to ask yourself some very simple questions. Where was the claimant hired? Where will the claimant file the claim? Where was the claimant injured? Where is the employer principally located? Where is the third-party lawsuit filed? And where is the tortfeasor located? These are the variables that go into the third-party considerations that go into extraterritorial subrogation. The advantage to us is the worker won't usually consider these subrogation rights up front. Even a lawyer will often not look to them. So we may choose a state which limits subrogation. He may choose a state which limits subrogation. For example, the Texas worker injured in Georgia, you're the lawyer. Let's say you're the lawyer for the worker. Should you choose Georgia or Texas benefits? Well, if you choose Georgia benefits, the claimant has the right to file suit for 1 year, and you have the Made Whole rule codified. If you choose Texas benefits, you have first money right of recovery. And if you choose Georgia benefits, the plaintiff's attorney can recover costs, but the kicker is, at the very bottom, with Texas benefits paid, you have no subrogation rights in the third-party suit in Georgia, and that's worth more than all of the above. Because as the attorney, you can then get your client more money in his pocket. There are 3 possible approaches to determine which state's subrogation laws apply. You look to the state where the lawsuit is filed. So if the lawsuit is filed in Georgia, you look at Georgia law. Georgia law will have a separate body of law called conflict of laws, and these laws will apply one of 3 or 4 rules to determine which state's law apply to determining your subrogation rights. The first one is lex loci delicti, the place of the wrong. It's really a minority. Only 12 states follow it. It applies the law of the forum state, like Georgia. So in Georgia, it's going to apply Georgia law to a Georgia statute, to a Georgia third-party case, even though Texas benefits were paid, meaning that no subrogation exists. The Larson rule, under Restatement 185, applies the law of the enabling state. So if you're in a state that applies the Larson rule, like Texas, and Georgia benefits are being paid, you're going to look to Georgia law to determine your subrogation rights, which means even in a lawsuit in Texas, if Georgia benefits are paid, you have the Georgia Made Whole Doctrine hanging over your head. Very common is the majority rule is the most significant context. This is really a cop-out. It's a state which hasn't made a decision on extraterritorial subrogation involving work comp yet, so it applies the general conflict of law rule, which is it applies the law of the state with the most significant context. And then lastly, you have a law which is very rare. It's the law of the forum, and that's if the forum is different than number 1 above. So the procedure is determine all of the variables that we discussed, determine the subrogation law of both states. This is where your education and these webinars come in handy, and the book. Determine if there is a conflict. If there is a conflict, that means there's a difference in law resulting in two different outcomes. And if you have such a conflict, then you apply the conflict rule of the forum state. Let's go through an example. Let's say you have an employee injured in a car accident in Georgia with a third party who has minimum limits. The employer is based in Wisconsin. The employer resides in Wisconsin. Benefits are paid under Wisconsin law. The suit is filed in Georgia, and the employee settles the case but is not made whole. All right, under these circumstances, first thing we want to know is we determine the law of both states. Both states allow for subrogation. Wisconsin subrogation allows, or Wisconsin subro law allows recovery if not made whole. Georgia's subro law requires the claimant to be made whole. Georgia law requires the carrier to prove that he's made whole. So in this example, is there actually a conflict? Under Wisconsin law, the carrier makes a partial recovery. Under Georgia law, the carrier recovers nothing. Clearly, that is a conflict because you have different outcomes. As a result, you now move on to Rule 4. If there's no conflict, it doesn't matter. It doesn't matter which state's law you apply. But if there's a conflict and different outcomes, you then apply the conflict rule of the forum state, the state where the suit is filed. If the suit is filed in Texas and Georgia benefits are paid, you apply Texas law. If the suit is filed, as in our example, in Georgia, you apply the Georgia conflict rule, which is lex loci delecti, the law of the state where the loss occurred, which is Georgia, which means you apply Georgia subrogation law, which means no recovery for the carrier. Example 2, employee slips and falls at work in Illinois. The employee's work-related injury is worsened due to medical malpractice in Illinois, but the employer is based in Iowa. The employee resides in Iowa. Benefits are paid under Iowa law. The suit is filed in Illinois. So we have Illinois suit, Iowa benefits. Let's go through the examination. Determine the law of both states. Illinois law allows for subrogation recovery in med-mal cases. Iowa law does not. Therefore, is there a conflict? Yes, you have different outcomes. There's a conflict. You apply the conflict rule of the forum state, which is Illinois. Illinois follows the Larson rule. Larson rule applies to the subrogation law of the state paying the benefits. Conclusion is, carrier cannot subrogate against medical malpractice recovery even though Illinois law allows it. The Illinois conflict law will apply the subrogation law of the state paying the benefits, which is Iowa, which does not. So, the gentleman shown on the screen, I'd leave you with a visual and with a quote from the original Terminator movie, one of the classics of all time. If you recall, it actually was the second Terminator movie in which the Terminator is standing in front of the garage protecting the kid and their mom, and he stands there motionless as night falls and then is standing there again at dawn. I mean, this is a machine that never sleeps, never stops, doesn't rationalize, doesn't reason, just fulfills his job and does so with the utmost force until it's accomplished to its perfection. I want to leave you with the idea that the investment that is subrogation really behooves us to be terminators when it comes to subrogation. The law is in our favor in most states. The fact that the law is being whittled away little by little is a byproduct of the fact that we've taken it for granted, that we haven't invested in it as we should. So it's just important to remember that phrase from the movie, listen, understand, that Terminator is out there. It can't be reasoned with. It can't be bargained with. It doesn't feel pity or remorse or fear, and it absolutely will not stop ever. This should be your mantra. This should be your creed when you're in a mediation or when subrogation counsel for you is in mediation. You have the right to recover. I don't care if the mediator gets mad. We have the right to recover this money back. It is basically guaranteed to us as part of the social pact that is workers' compensation. We're going to answer some questions offline, and because those of you who are reviewing this recorded version will not get the questions, but I do urge you to attend some of our upcoming webinars. Again, a reminder, the next webinar coming up is September 16th, 2010, from 10 o'clock to 11 o'clock Central Time. It's 1 hour on construction defects, subrogating construction defects, and defending construction defects as a whole. Matthiesen, Wickert, and Lehrer represents Pulte Homes, the largest home builder in America, for all of its construction defects around the country. And I think this course, which covers the nuts and bolts of construction defect subrogation, will be invaluable to you. And again, if you have any questions with regard to subrogation credits, contact Jamie Breen. Also contact her to be part of our newsletter. And for future credit issues, or if you want a copy of the PowerPoint, her email address again is jbreen, J-B-R-E-E-N, @mwl-law.com. I thank you for attending, and we look forward to seeing you at the next webinar.